to mention item number 13, my lord. Can this matter be taken over after 10 days, ma'am?
1-3.
1-3.
Yes, agreed by both the sides. List the matter after 2 weeks. What did you say? 2 weeks?
After 10 days, 2 weeks?
After 10 days, after 2 weeks. 1-3-13.
1-3.
May I please, your lordship?
Yes, yes.
With the consent of the other side, lordship, I beg to mention item number 10, lordship. I'm paying for adjournment of this matter, lordship. Matter may be taken up after.
Lordship, the matter may be fixed on the.
Heavy slip diasani. Adjournment slip diasani.
Lordship, I am for the other side.
Okay.
10.
Let the matter be fixed in this coming Friday, Lordship.
Coming
So-
Friday?
Lordship, my.
I've already informed them. They have agreed to.
I mean, coming. No, not possible.
They are on 16th September,
16 Pine. Yes, on 16 September.
Lordship.
Learned Council, Mr.
Yeah, Kashyap.
A. Kashyap on behalf of
I Soikia.
Learned Council, Mr. I.S. Sukia, with the consent of the other side.
Yeah.
has-
A. Acharya.
With the consent of Learned Council, Mr. A. Asardia, has prayed for adjournment, list the matter on 16 colon.
Lordship.
May it please your
Mm.
lordship, I beg to mention item number 12. Senior is out of town, your lordship. Kindly fix the short date.
Learned Council, Miss.
F.
Your
Sharma.
lordship, I am for the respondent, your lordship. Your lordship, matter may be fixed on 9th next
9
Tuesday.
September, Pine.
Long pending case, your lordship.
Okay. Learned Council, 9 September, Learned
Yes, sir.
Council, Miss A. Sharma has submitted that her senior, Mr.
D. Chaudhary. is
A.K.
out of-
Chaudhary.
D. Chaudhary.
Mr. D. Chaudhary is out of station. Learned Council, Mr. J. Borbia.
S. Paul on behalf of Jai Borbia.
As for on behalf of Mr. J. Borbia is present for the respondent number 1 and 2. He goes till 9 September. Please the matter on 9 September.
Highly
Deeply
obliged.
obliged.
May it please. No, with the consent of the others, I beg to mention item number 20, my lord. 20, my lord. Any date, my lord, after 1 week, my lord.
Learned Council, Mr. S. Doctor, with the consent of the other side, has prayed for adjournment, list the matter. When you want? 11 September?
September. Highly obliged.
Item number 1. Oh, mediation. Item 1. Item number 1. এইটো নাহেই দেখোন কেতিয়াও। Parties are not present on call. Full stop. Earlier on 29/5/2025, the parties were absent without steps. List this case positively on for referral to special mediation drive, failing which necessary order may be passed. Kiman dila? List the matter on 10 September.
Lordship, this matter was fixed for hearing. Strongly requested.
You will submit or we will send it for mediation. You'll submit on hearing. Is there any element of settlement?
No, Lordship, it may come for hearing. It was fixed for.
You are not willing to settle the dispute through mediation.
Mediation, yes. Lordship, this matter may be revert to mediation.
One side will say refer to mediation, the other side is not willing. Cannot be referred to mediation. When the other side is not willing, how can we refer to mediation? You are not willing to settle the dispute.
No, Lordship, it may come for hearing.
You are for insurer,
No, I'm for the.
claimant.
Payment.
I'm from the respondent.
Your what are you offering? Are you offering something?
Okay, Lordship.
Will he agree to your offer?
Okay.
Yeah, we are offering him rupees 10,000. That's it.
Who is for the insurance?
No, this is a matter bill. It's a matter.
That is why I'm asking, who is for the insurance? No, nobody is for the insurance, driver and owner and the claimant.
No, this is lordship is a matter, matrimonial.
Oh,
Matrimonial appeal.
I thought it is make appeal. Husband and wife.
Yes,
Yes.
You are offering 10,000 per month.
Yes.
You are the husband.
yes, Lord.
The wife.
Are you willing to accept?
Okay.
Willing to accept. So we'll send it for mediation then.
Okay, Lord.
Learned Counsel, Mr. Your name?
Yes, Borough.
As Borough is present for the appellant. Learned Counsel, Mr.
HR Khan.
Isha Khan is present for the respondent. Full stop. It appears that there is an element of settlement. Full stop. Thereby, this case is referred for mediation to the High Court Mediation Center. Full stop. Who is the, he is called a member, or what is the person called who is conducting the mediation? Mediator?
Yes.
Mediator? The mediator to issue notice to both the parties for appearance for a date to be fixed by the mediation center, and after completion of mediation, send a report within 2 months from today, or should I fix a date? Send a report on
Excited.
parties are directed to appear before the High Court Mediation Center, or should I give you a date? No, you have to report
Excited.
on this case is on the data details on Indian side. No, this case is thereby forwarded for mediation and for report on 3rd of November. 9 September, Mazada Bhaiba.
I can see.
May it please your lordship. Your lordship, in this case, we have denied both liability as well as quantum, your lordship. So there is no scope for mediation here, your lordship.
No
We have
scope of
no scope.
settlement.
The company is not willing to go for mediation. your
Lordship, even the respondents are not willing to go for mediation.
lordship. It will be finally heard, your lordship. Otherwise, service is completed and LCR has been received, your lordship. Any date may be fixed.
All are present, but all the respondents are
Lordship, I'm
present.
waiting for the respondents, for both the respondents.
For
One
both
and
the
two, 3 and
respondents.
4 has been struck off, your lordship already. There, respondent number 3 and 4 has already been struck off,
Okay.
your lordship.
Alright. Learned Counsel, Miss, your name?
P. Bothakur.
P. Bothayo is present for the insurer, and Learned Counsel, Miss I. Borua. No?
Lordship P. Burua.
P. Borua is present for the respondent number 1 and 2.
My lord.
It is submitted on behalf of both the sides that there is no element of settlement. Full stop. Both the parties are not willing to settle their both the parties are willing to contest the case and submit their arguments. Leave this matter for hearing on after Puja vacation.
After vacation, any
Puja?
Vacation.
After Puja vacation.
obliged.
Deeply obliged.
Item number 4 for others.
My lord, please. My lord, this is an application IA 2697, my lord, which I have filed for the release of 50% of the money which has been deposited, my lord. That
Counsel, Mr.
AB there, my lord,
ABJ is present for the applicant stroke appellant and has submitted this application with prayer
who direct
for
the registry,
withdrawal,
who direct the registry to release
with
the-
prayer to direct the registry to release the money deposited by the insurer.
Yes, ma'am.
To release the 50% of the compensation amount deposited by the insurer. Full stop. Learned Counsel, Mr.
A Bhattacharya.
A. Bhattacharya is present for the insurer stroke opposite party stroke appellant. Full stop. No objection has been raised on behalf of the insurer. Full stop. The registry is thereby directed to really release the 50% of the amount deposited in favor of the applicant after proper verification. After
Help.
proper verification relating to the identity and identity of the applicant. So should I give a time frame?
No,
It's okay.
already deposited.
In terms of the above
Deep-
observation, this application stands disposed of. Anything else?
IA may be listed for LCA to call isn't it?
LCA call for us.
LCA
was called early.
We have the LCR. We'll fix it for.
I will fix it for hearing, my lord, on that case.
This has been admitted already?
Yes, appellate has been admitted.
Any other IA? No other IA?
No other IA.
As the, আগত লিখি দিয়া, হেৰিটো, make appeal to লিখি দিয়া, এইটো. Both the parties are represented as the LCR is before.
After
us.
vacation, my lord.
After vacation
After vacation.
or in its usual course. This is
You
a
know,
matter-
after vacation.
this is a matter of 25.
Yes. But
Hmm?
small issue, I think only the income has been
Is
challenged.
this matter for hearing after vacation, Puja vacation?
Deeply obliged, my lord.
May I please, your lordship? I have filed this IA for fixing a date of early hearing, lordship. Since 2019, the petition is pending, lordship. And I was in both the cases in lower court, I was
Fix it
the,
for early hearing.
lordship, a date may be fixed after puja.
Okay, a date after puja.
In the month of November, my lord.
Hmm?
In the month of November. Well, October it will,
October, lordship.
October, half of
Yes.
the October is, my lord, gone.
My lord convenient.
Yes.
Certain, sir.
Till
Early
the-
hearing or date.
A date may be fixed.
On 28,
8th
28,
of October.
28, 28.
28 October.
Deeply obliged.
Learned Council Miss S. Sil, no?
As Kanun, your lordship.
S. Kanun Go. Etu heri, I don't likiba, ha? Learned Council Miss S. Kanun Go is present for the applicant and Learned
T
Council
Sheikh, my lord.
Mr.
T Sheikh,
T.
Sheikh, SK. TSK, my lord.
T. Sheikh is present for the respondent or stroke opposite party. It is submitted on behalf of the applicant that this matter has been pending since 2019. And this matter may be fixed for early hearing. I have considered the submissions at the bar. List this petition application is allowed. List this matter for early hearing on 28 to
10.
8 October.
Deeply obliged.
28 in terms of the above observation, I stands disposed of.
All right, my lord.
My pleasure, Lordship. My lord, in this appeal,
Hmm.
I have been recently engaged for the respondent. Therefore, I want to some time.
Let it come day after tomorrow, my lord, in that
The day after tomorrow, it will not be possible.
Recently engaged. You
Let
see,
it
it's a second appeal recently engaged.
But it is very old one.
You
let it
understand,
be
but recent
listed
cases-
after,
Within 2 days, what he want? What will he,
after,
at least 1 week?
no, after Puja vacation.
Puja vacation.
Puja vacation is coming.
No, not Puja vacation. Maybe third
After
week,
vacation,
third week?
Okay.
Third week of September?
okay.
Yes,
23rd.
let it be on 23rd, my lord. In 23rd.
Then we will go back to Puja vacation then,
16,
16 October,
no, 16 September, third week.
18th or 16th, anything,
16.
16th,
18. Let it be 18.
okay.
No, but
Will that
16,
be sufficient for you?
my lord, it may be fixed on 23rd of September.
23rd of September, I think that will be a week for motion.
It is Tuesday.
These would be the motion dates.
No, 23rd is Tuesday, hearing day.
No, but I think that entire week will. be-
Puja vacation is very near.
Oh, I
That's why
see.
those days would be the motion dates.
Any day in the fourth week of September.
Let us go back to October then.
16.
October, it will be better, man.
October,
18 or 16, my lord, those are the hearing dates.
18 number 16, 18 or 16? September, 18 or 16 September? Learned Counsel, Mr.
AC sir.
AC Sharma is present on behalf of the respondents and has submitted that as he has been newly engaged, he requires some time to go through the record. Learned Counsel, Mr.
OP Bhatti. OP Bhatti.
OP Bhatti is present for the appellants. List this matter on 18 September.
No problem.
After some time, Lordship, my senior leg another court. Item 8 also, Lordship.
After some time.
Very uncertain. Sometime means very uncertain. Take a date. Take another date. I'll have to wait for an entire day. Demand time, go. Sometime is very uncertain thing.
Maybe you have any
Yes,
other
yes.
engagement.
Yes.
Okay.
After some time, he is coming, Lordship, leg another court, Lordship.
Better fix another date, my lord. Because,
5 minutes, she'll get back to me after 5 minutes.
no,
Item 8 also, Lordship.
Yes, yes.
What is there?
What about this side?
I am for the owner. He is claiming. Appellant insurance company is the action.
Let it be. Lordship.
Last date he was present, but this day, today he is not present.
At her instance, the matter was listed today.
Today.
Oh, yes.
Yes.
At her
Yes.
instance,
Yes.
Let it be after
Mrs. Pal
vacation.
was there.
After?
After this vacation, any date
Any date may be fixed after
after
the
vacation. We'll do it comfortably.
It's 10:45 only. Can we wait or you are not willing to wait? No.
I have 2, 3 items.
Okay, okay, all right, all right. Appellant is not represented, appellant is not represented. Learned Counsel, Mr.
I.S. Borgia for the claimant.
I.S. Borgia is present for the claimant and Learned Counsel, Mr.
I am for owner, man, 2.
Uh,
Here respondent number 3.
okay,
In appeal, respondent number 3.
A.I. Uddin is present for respondent number
3.
3. Okay. Okay,
She has come.
yes. All right, ready for hearing? Okay. चलो काट लीजिएगा, हाँ?
This appeal is filed against the judgment and award dated 2/7/2012 in MSC case number 411 of 2011 Milo. Awarded amount is 5,70,000. Death case Milo. May I read the judgment? May I read the judgment?
Yes, the operative part you can read, yes. As it is, I'll read, so you can read it.
And this MSC case arises out of the petition filed by the claimant C. Madan Pal under section 166 of the MB Act 1988 for seeking compensation on account of death of his brother by a motor vehicular accident. Brief facts of the case of the claimant is that on 30/5/2011 at about 12:30 p.m. when the claimant brother deceased was working under the standing truck bearing registration number so-and-so at Lanka Juri Mother Tele under Daboka PS, another vehicle bearing registration number so-and-so driven in a rash and negligent manner, an excessive high speed hit back side of the vehicle number so-and-so, which was standing on a side due to a mechanical defect. In that said accident, his brother Dharmendra Pal got serious multiple injury, and as a information about the accident, claimant Sri Madan Pal rushed to the place of occurrence and with the help of police, claimant took the dead body for postmortem at Noagaon BP Civil Hospital. Thereafter, police returned back the dead body to the claimant. Claimant carried the dead body to Rangia, Kamrup for burial and arranged Shraddha ceremony there. Claimant spent more than rupees 50,000 for Shraddha ceremony. An FIR was lodged with Daboka PS. In this regard, a case has been registered as Daboka PS case number so the petitioner claimed rupees 12 lakhs only as compensation for death of his brother. On receipt of notice, OP number 2, 4, and 5 appeared and contested the case by filing WS. OP number 1 and 3 did not contest the case by filing WS. OP number 5, National Insurance Company Limited filed WS, wherein the OP5 has taken the usual plea of denial and stated that the liability of the OP, if any, is subject to terms and conditions of the insurance policy. OP number 2 and 4 stated that there is no cause of action for filing the claim petition. The claim petition is silent, vague, ambiguous, and defective in materials, particulars, and hence liable to be dismissed in law. The OP number 2 stated that the truck bearing registration number so-and-so was a standing truck and also mechanically defective, and the mechanic deceased was working under that truck. Hence, this truck is not liable for any corner. The offending vehicle number was duly issued with National Insurance Company Limited at the material date and time of accident, and also duly armed with all valid documents like tax paid, registration certificate, fitness, etc. And the OP number 3, the driver has a valid driving license valid up to so-and-so. That the offending vehicle number so-and-so was insured with the National Insurance Company Limited, Kolkata at the time of accident, and risks was covered under the insurance policy. Hence, OP number 1, 2, 3, and 4 are not liable to pay any amount as compensation claimed by the claimant. These OPs are entitled to be indemnified under insurance policy cover note number so-and-so valid for 1 year from the date of issue. The offending vehicle was insured with National Insurance Company Limited. The policy cover number so-and-so and the OP number 3 has a valid driving license number so-and-so valid up to 6/2/2012. On the pleading above, the following issues are framed: whether there was an accident on 38/5/2011 at 12:30 p.m. involving vehicle number so-and-so and so-and-so, whether the offending vehicle was driven in rash and negligent manner, and whether the claimant's brother died in the said accident, whether the claimant is entitled to get any compensation as prayed for, to what relief the parties are entitled to. I have heard both sides and also examined the evidence laid by the claimants as well as the The claimant in his claim petition has given the description of the necessary particulars such as name, address, occupation, and income of the deceased, the place, date, and time of accident, the registration number, name, and address of owner and driver of the offending vehicle. Further, the claimant has mentioned the name of the insurance company of the offending vehicle and the policy cover note number so-and-so of National India Insurance Company Limited. In support of his claim, the claimant Madanpal has examined himself as PW1 and supported the contents of the petition. In his evidence, he also stated that the accident took place on FO when the claimant brother deceased Dharmendra Pal was working under the standing truck bearing registration number so-and-so at Lanka Juri, Madhyatal under Daboka PS. The another vehicle bearing registration number so-and-so dumper by rash and negligent and excessive high-speed manner of driving, the said vehicle hit from backside of the vehicle number so-and-so, which was standing in a side due to a mechanical defect. In that said accident, his brother Dharmendra Pal got serious multiple injuries, and as a result, he died on the spot. The claimant stated that his brother worked in a garage vehicle repairing center at Veluguri, and he earns rupees 9,000 per month. The claimant claims compensation of rupees 12 lakhs for his family. The claimant also stated that an FIR was lodged with Daboka PS and obtained from 54 accident information. He also exhibited the following documents: Exhibit 1, claim petition; Exhibit 2, postmortem report; Exhibit 3, death certificate; Exhibit 4, income certificate; Exhibit 5, Gawbura certificate; Exhibit 6 and 7, photograph of the deceased; Exhibit 8, form number 54; Exhibit 9, 10, 11, 12, expenditure regarding Sadhya ceremony. In his cross, PW1 denied that he could not submit the birth certificate of his deceased brother. PW1 also denied the defense suggestion that deceased could not earn rupees 9,000 per month. It is not a fact that he could not produce any documents for shifted the dead body to Rangia. It is not a fact that the claimant is not entitled to get such compensation. On behalf of owner number 2, PW1 stated his brother was working under a mechanically defect truck. He also stated that standing truck was hit by a running dumper, registration number so-and-so. PW2, Sri Birendra Pal, he also stated the same as PW1. PW2 stated that he saw the incident about 100 to 150 meter distance. PW2 stated that the accident occurred due to hit by a dumper from backside to a standing truck. As a result, claimant brother died on the spot. He also stated that he went to BP Civil Hospital along with Madanpal for postmortem. In his cross, PW2 denied defense suggestion that he did not go to BP Civil for postmortem. He also denied defense suggestion that he did not see the deceased working under the mechanical defect truck. On behalf of OP number 2, PW2 stated that there was no driver or owner in the mechanical defect truck at the relevant time. I have carefully considered the evidence on record and I find that the claimant is able to prove the occurrence by adducing convincing and oral and documentary evidence. I also find from the evidence on record that the claimant is able to prove that the offending vehicle was being driven in rash and negligent manner and hit the standing on a roadside mechanically defect truck, and as a result, claimant brother who is working under that mechanically defected died on the spot. In view of the above, these two issues are decided accordingly. There is no dispute that the offending vehicle was involved in the said accident. There is also no dispute that the death of deceased occurred in the said accident. However, the offending vehicle has insurance coverage policy number so and so valid for 1 year from the date of issue, and the driver has got a valid driving license number so and so. Let me come to the most vital question of quantification of compensation. The claimant has claimed compensation without showing any head thereof. The claimant in his claim petition as well as in evidence stated that his deceased brother's monthly income was about ₹9,000 per month, which he earned by doing mechanical works on a workshop garage at Madhepally. The claimants also produced one income certificate issued by the owner of that Mondal workshop at Madhepally. As per the income certificate, deceased monthly income was 6,000 and daily allowance was ₹100. However, I am not inclined to accept the income as mentioned in the certificate. At the same time, I shall consider the fact regarding income on the basis of what has been gathered from the materials on record. It is to be presumed that the deceased worked.
Yes, yes.
Yet,
You are the insurer.
I am the insurer of the dumper mill, offending vehicle.
Why are you aggrieved? Why are you aggrieved?
My lord, in this case, the truck which was in standing position, it is under mechanical defect, and without showing any symbol, the truck was standing on the road, my lord. Without showing
Without any
signal.
Yes, okay.
They're showing. So secondly, my lord, the claimant was the major brother of the deceased, my lord. Claimant was the major brother of the deceased, and there is no substantial evidence to show that he was dependent on the income of the deceased, my lord. Thirdly, my lord, here the claimant was considered as 26 years, my lord. And as per Sarala Verma decision, the multiplier should be 18 instead of 17, my lord.
Multiplier will
Was
be
taken 18 instead of
multiplier would have been 17.
17.
So that brother is
Brother was the major brother was the claimant, my lord.
he according to you, he has his own income.
Yes.
And anything else?
No, my lord.
But so far I am concerned, my lord, in main case I was opinion number 2, here 3, respondent number 3.
Yes,
I am
number
the
3.
owner of the standing vehicle, and they have raised the plea of composite liability here.
You have in this case, or you have raised the plea of composite liability in the earlier
No,
case?
this is my submission. Your lordship kindly already have gone through the judgment. Your lordship, for a moment, only just relevant portion.
You have a respondent number?
Respondent number 3, owner of the vehicle which was defective and was standing nearby the roadside. No.
Defective and standing by the roadside, yes.
Yes.
Other witnesses have stated.
OP has taken usual plea of denial and stated that the liability of T is any subject to term and condition of the insurance policy. So the plea of composite liability, whatever is taken here, that has not been taken during the trial. So on that, my submission
Not
is
taken during the
no.
trial?
This is apparent, my lord, in the judgment itself.
We have denied our liability in written statement, my lord.
Therefore, I am referring one judgment of Sikkim High Court, my lord. Referring the various 2-3 judgment of the Supreme Court, my lord, it was held.
No, they are not admitting to any composite liability. They have already totally denied their liability.
Now they are pleading. They are pleading that they have simple denial, usual denial. The plea of composite liability here in the appeal, they have taken that the vehicle which was standing nearby the roadside ought to have used precautionary signal, etc.
Yes, yes.
That has not, that plea, it is a new plea in the appeal. That the plea has not been taken in the trial. So this is my submission, and on that matter, I am relying this judgment.
Okay. Miller, this plea was not taken in the original case.
This is
That
apparently,
no signal was
Their
used.
claim petition
while
is,
the- huh?
their claim petition is silent, whether the vehicle was standing, taking all the precautionary measures, the vehicle pleading was silent.
I am not for the claimant, so my submission will be on that line only. The ground 2 of the appeal. So, your lordship kindly peruse this judgment. I am just referring the relevant part. Page 5 of the judgment, paragraph 6. Paragraph 6. Page 5.
Yes.
Having considered the opposing argument advanced by the learned counsel for the parties in extenso, and having perused the record placed before me, the questions that fall for consideration before this court are: number 1 is relevant. Can a new ground be urged in appeal when it was not raised before the MSET? Now, answer, my lord. Point 1. While addressing the first question formulated absolutely, it has to be noticed that the question of this measure that was taken never raised by the appellant before the learned MSET. All that appellant averred in the written statement at paragraph such and such is such and such, such and such. Be that as it may, the Supreme Court dealt with a similar circumstances. Is a new ground raised in appeal in such and such and observed as follows. Their observation of Supreme Court. It is even does not appear that the contention raised before us had either been raised before the tribunal or High Court. The tribunal also in the High Court therefore proceeded the material brought on record by the party in absence of any contention having been raised in regard of the applicability of such and such, which in our opinion exercise has no application. The same in our opinion cannot be permitted to be raised for the first time. Another judgment referred. Therefore, point number 3. In view of the above settled position of law, as expounded by the Supreme Court herein above, it needs no reiteration that a new ground cannot be urged in appeal when it was not raised at all before the learned MSET. Hence, the argument pertaining to such and such a new ground in appeal is not sustainable in law and accordingly disregarded. So this is my submission. There, your lordship has already given the judgment itself. There is a reflection, except a formal denial, nothing specific. So this ground is, they are not permitted to. So this is my submission on it.
Yeah, for the
He is claiming. So, my lord, may I be permitted to leave the court?
Yes, yes.
This is my, I am like. You know what?
Lordship, here I am claimant, your lordship. Their main grievances was the lordship calculation of my income and all these things. Calculation of the income and deduction of 50% was not done.
Okay.
Here, there is a plea. 2/3 has been main income from the main income, 2/3 has been deducted, but their claim is 50% as per the.
He is unmarried.
Unmarried. So as per their 50% deduction was not done. What if
No, I am not pressing this one. 50% was deducted. This is was an unmarried person, so you'd have spent 50% of his income for his personal expense. I'm not,
actually deducted? Now he is not present.
no, I am not pressing
So-
this ground.
She is not pressing. So I think you cannot press.
Not. This has already been done, is reflected in the judgment also. Other thing, your lordship, this is reasonably calculated, your lordship, multiplied by 18, all these things, your lordship, is very quite reasonable. And
I don't know, I'll have to go through that table, Sarla Verma's case.
For Sharla Verma, just the multiplier is he 17 in this.
You have the table?
Yes.
Income was claimed 9,000. On tribunal what fixed is 5,000. Already been deducted quite reasonably. Your
Yes,
lordship.
I think so.
Yeah,
I think so, this,
quite
let
reasonable.
me see the table by the way.
Since I was in mechanics and income proof was also been showed 6,000 per month and additionally 100 per day. It has been shown and reduced before the tribunal.
What was his age?
Age is also the claimant is 26, your lordship.
26.
Lordship.
Column number
26.
four will be calculated.
And this is age was 20.
Was 20.
This is was 20.
Now the claimant is major brother, so which multiplier, which is a very higher is to be taken.
Hmm?
Is whichever is higher is to be taken, my lord.
Yes, yes, because it was this accident occurred in the year, which year? Then we did not have the Pronicities case.
Lordship.
In the year 2011. 2011.
So we'll have to stick to this case only.
Lordship. 2011. 35 2011.
It will be 17. You can check, it will be 17.
Lordship, I have lordship.
You have, no? I think it is 17. Now I get media as a question.
In that case, the compensation would come to rupees 5,40,000.
And how much
It is 5,70,000. 30,000 crores, I think.
30,000. That much, maybe. I don't know.
Do you have any judgment supporting that this lower has to be not supporting, rebutting that the lower age has to be taken into consideration instead of the higher age? Here we have that we'll have to consider 26 to 35 range.
Okay.
But any judgment after 2005, this is 2005 judgment, isn't it? Sharla Verma's case, 2009's judgment. I think we'll have to stick to this judgment only. On the basis of the Trilok Chand's table. And then you are suggesting that we'll have to stick to that range from 26 to 45. Which paragraph? Please find me the paragraph. Mati diwa kabat. This is the Trilok Chand's table that will be required, and then the other submission you have given.
Discussion was made from paragraph 33, my lord, regarding multiplier.
Paragraph 33.
Okay. Paragraph 33. 33 onwards, my lord.
I'll pass the order now.
Lordship.
Okay, then, in case you want to submit some more while I'm dictating the order, you can place your submission. You can interfere and place your submission. And if there is any wrong statement made, you can just interfere and correct me. It like it.
Lordship, may I leave, Lordship?
Of course, of course.
I leave like that.
But learned counsel Miss S. Roy, no?
Yes, Roy,
For the
for the appellant.
appellant. Comma, learned counsel Mr. নাম কি নিয়ে উলিয়াই ল'বচোন AI Uddin for the respondent number 3 and learned counsel Mr. কি হয় এওঁৰ নামটো ক্লেমেন্টৰ আৰু ক্লেমেন্টৰ respondent number 3 and learned counsel Mr. নামটো উলিয়াই লৈ পেলাই দি দিবা দেই for the claimant. Huh? Highest board here for the claimant. This appeal is preferred by the National Insurance Company, comma, National Insurance Company within bracket herein after referred to as the appellant or the insurer. The claimant is arrayed as the claimant, Sri Modan Pal is arrayed as respondent number 1, comma, the owner of the vehicle bearing registration number is 02E stroke 6346 as respondent number, comma, Sri Pachu Gopal Mujumdar as respondent number 2, comma, the owner of vehicle bearing registration number is 02E stroke 2368, comma, as respondent number 3, comma, the driver Sri Ganesh, that they were struck off, no? Respondent number 4 and 5.
I have not gone through the documents.
নালাগে থাকে তো ওনার যে লিখিছিলা 6346 ওনার নামটো লিখিছিলা ন তাৰ ভিতৰত লগাই দিয়া ড্ৰাইভাৰ শ্ৰী গণেশ দাস এছ ৰেছপন্ড নম্বৰ 4 আৰু এইটো ওনাৰ লিখিছিলা যে তাৰ লগত লগাই দিয়া মোহাম্মদ খাইৰুল এছ দ্য ড্ৰাইভাৰ মোহাম্মদ খাইৰুল ইছলাম এছ ৰেছপন্ড নম্বৰ 5. First of the insurer is aggrieved by the judgment and order dated 2/7/2012 passed by the learned member MACT Sankardev Nagar Hujai in connection with MSC case number 411 within bracket capital N stroke 2011 judgment and award likhi diba order comma awarding a compensation of rupees 5,70,000 to the claimant, directing the appellant to pay the compensation along with interest at the rate of rupees 8% per annum from the date of filing of the petition till payment. the genesis of the case was that on 30/5/2011 at about 12:30 p.m., the claimant's brother was working under a standing truck bearing registration number AS 021 stroke 2386 at Lonkajuri, Modatoli under Dabaka PS, who stopped at that time another vehicle bearing registration number AS 02 capital E stroke 6346, a dumper, driven in a rash and negligent manner with excessive speed, hit the standing truck, which was parked on the side, full stop. As the truck was parked owing to a mechanical defect, the Sri Madan Pal's brother, Sri Madan Pal's, লিখি পেলাই PAULS Pals, তাৰপিছত within হেৰি bracket এটা লিখি দিব, bracket herein after record close the claimant, bracket close, তাৰপিছত লিখি দিব brother who was working under the standing truck sustained injuries as a result of the accident, and he died on the spot. His body was forwarded to BP Civil Hospital, Nagaon for post-mortem. Brother নামটো এনেকে লিখি দিব হা, brother ধৰ্মেন্দ্ৰ পাল. The claimant had to incur expenses to the tune of rupees 50,000 for the funeral rites. Full stop. And next prayer likha, an FIR, next prayer halal. An FIR regarding this incident was lodged and registered as Laboka PS case number 7/2011 under section 279/304 within bracket capital A stroke 427 of the Indian Penal Code. Full stop. The claimant has prayed for a compensation. Claimant prayed for, he has not, prayed for a compensation of rupees 12 lakhs. Full stop. in the original MSC case number 411 and 2011, the owner of the standing truck, the owner of the allegedly speeding truck, allegedly speeding truck, comma, the owner of the standing truck, comma, the driver of the allegedly speeding truck, and the driver of the the driver of the, comma, the driver of the standing truck, comma, the insurer of the allegedly speeding truck and the insurer of the standing truck were arrayed as respondent number 1, 2, 3, 4, 5, and 6 respectively. Against the claim petition lodged by the claimant, comma, the OP number 2, 4, and 5 contested the proceeding and filed written statement, whereas the OP number 1 and 3 did not contest the proceeding.
Moi for 3.
The OP number 2, 3, and five, through their separate written statements, have denied their liability the it was admitted by the OP number 2 that as the truck bearing registration number AR02 2386 was mechanically defective and was standing, comma, and was parked, and as the deceased were working under the truck, comma, the owner is not liable owner cannot be held liable. On the other hand, the OP number 3 has stated that the insurer that he can be exonerated from his liability as his truck was duly insured by the OP number 3. Full stop. The truck had all the his vehicle had all the valid documents like registration certificate, fitness certificate, and the driver was holding a valid driving license, IEF 29/KA/09/TV, which was valid at the time of the incident, as the license was valid up to 6/2/2012. The insurer has, on the other hand, questioned the income of the deceased, age and income of the deceased. First of the learned, it was held by the learned tribunal that it was held by the learned tribunal. It is submitted on behalf of the appellant, who was the insurer of the truck bearing registration number AS016346, that the truck was parked without any precautionary measures on the road. Full stop. The vehicle which was proceeding was not aware and unawaresly the vehicle which was proceeding away and unawares the vehicle hit the standing truck. It is further submitted that the claimant is not entitled to any compensation as he is not a minor and he is a male member, not a minor and a male member, being the brother of the deceased. First of moreover, it is also contended that the multiplier was erroneously that the multiplier 18 was erroneously used to calculate the loss of dependency instead of the multiplier 18 as per the decision of the Honorable Supreme Court in Sarla Verma and others versus Delhi Transport Corporation, and another reported in within bracket 2009 bracket close 6 SCC 121. Next parallel per contra the learned counsel for the
One.
You are the owner of which truck? That standing truck? Or learned counsel for the respondent number 3. Learned counsel for the owner of the truck who is arraigned as respondent number 3 in this present appeal laid stress in his argument that the plea of lack of precautionary measures adopted by the standing truck was not taken in the original proceeding. Moreover, the plea of composite liability was also not taken at the stage of trial. And now they continue to And now at this stage, at the appellate stage, a new plea cannot be introduced. The learned counsel for the respondent number 3 has relied on the decision of the High Court of Judicature at Sikkim, Gangtok, in connection with MSc Appeal number 8/2024, wherein it has been observed, paragraph 6, oh, it too very, in MAC Appeal number 2000, wherein wide order dated, wide order dated 21/11/2024, it has been observed that paragraph 6 paragraph 2, দুটা পেজত আছে 5 or 6 দুটা পেজত আছে টিক মার্ক লিখা আছে the learned counsel for the claimant laid stress in his argument that the deceased was a bachelor and 50% ought to have been deducted as personal expenses, which was not so in the present case, full stop. Decision of the heading error, decision of the trial court liquidable. Decision of the tribunal liquidable. Heading error. It has been held by the learned member MSCT Nagaon niki. This is Moiga. Learned member. Oh, Hojai Sankodev Nagar. Learned member MSCT Hojai Sankodev Nagar that the claimant has given all the required details through the AIR, Accident Information Report, within bracket AIR for short. Oh, no, to the claim petition, AIR, which reflects the names of the insurance company, the policy number being 15050316738 of the National Insurance Company. To stop, to substantiate his claim, he has stated as PW1 that the accident occurred on 30/5/2011 when his brother Dharmendra Pal was working under the standing truck bearing registration number AF02E/2386 at Lonkajuri, Modotoli, MODERTOLI. He has also substantiated his claim that at that time, he is substantiating his claim like at that time another vehicle bearing registration number A021 6346 stroke at 21/6346, a dumper proceeding with excessive speed hit the standing truck hit the back of the standing truck, which was parked aside owing to a mechanical defect. Full stop. his brother succumbed to the injuries sustained as a result of the accident. Full stop. And his brother was working in a garage at Bheloguri, Velouguri, with a monthly income of rupees 9,000. He has marked the FIR as Exhibit 1. It was observed by the learned tribunal that as the claimant's brother, who was working under the mechanically defect truck, died as a result of the accident, the rash and negligent act of the driver of the vehicle was discernible. Could be deciphered, was discernible, could be deciphered, DECIBHERET. It has also been held by the tribunal that the evidence of PW1 has been substantiated by the evidence of PW2, who is the owner of the standing truck. Full stop. C. Brenda Pal stated that he had witnessed the incident which took place about at a distance of about 100 to 150 meters. At that time, the deceased was working under the standing truck. He also accompanied the body of the deceased to the hospital. He has also affirmed that no driver or owner of the standing truck was present at the time of the accident. Can we লিখি যান PW2 owner of the standing truck বুলি যদি লিখিছা কাটি দিবা হা কাটি দিবা এইটো কাটি দিবাচোন PW2 owner of the standing truck টো কাটি দিবা নামটো লিখি দিবা বীৰেন্দ্ৰ পাল It was held by the tribunal that as the evidence of PW1 and PW2 has substantiated the claim from us. it has been proved that the vehicle bearing registration number AL 021/6346 was the offending vehicle. Full stop. It was also held by the tribunal that the vehicle ought to be, or that the owner of the offending vehicle ought to be exonerated as the vehicle was duly insured as the policy, as the policy number 15050316738 of the National India Insurance Company Limited was valid at the time of the accident. As the policy was valid up to 31/3/2011. Forty-two, which paragraph? According to you, that Sharala Verma,
45.
whose age should I take? The victim's age or the brother's age?
Brother says.
Brother's age, which paragraph in this case? 42, definition. Because there are decisions that, later decisions that we must take the victim's age. But here,
Here is the claimant.
but later decisions I know, but
The age of the claimant Miller.
that this incident was in the year 2011.
They also did not challenge this finding of the tribunal. Claimant
Okay,
also.
I'll ponder over it and then I'll dispose it. You'll find the order in the website. I'll dispose it. I'll check this. I'll have to read it. Because I know of some decisions. I'll check it. Yeah, put it. It is Google, not Yes, you were waiting for 5 minutes, no?
Yes, first I am ready. The advocate has come.
Now you're
I am ready.
You ready?
Yes.
Okay then, we'll hear you. Okay. I'll come back after 5 minutes. This time I'm taking 5 minutes.
No problem.
মোট ফাইলটো লৈ গ'লে মই ক'লো 22 নম্বৰ কোৰ্টত আছো তাত ফাইলো নাই কেছ কৰিব ক'ত গ'ল ফাইলটো কি যাব লাগিছিল না মোক তাৰ ফোন নম্বৰ আছে না ফাইলত যাতে ফোন নম্বৰটো আইয়ে করবো যাবে
This appeal is for enhancement. And we have lordship basically taken several lordship wrong has committed in this judgment. My lord, multiplier that has been taken wrongly. Number one. Number two, lordship future prospect, no award was given. Loss of consortium is given only 10,000. Death case lordship. Funeral expenses 5,000. And no loss of estate. Number one, lordship multiplier. Number two, future prospect nil. Loss of consortium only 10,000. Funeral expenses 5,000 only. And loss of estate nil. And interest is given from date of judgment, not from the date of filing of claim petition. And income, lastly, lordship income of the deceased was taken only 3,000, notional income. So
what income, what?
Income was taken as notional income only 3,000. He was a carpenter, age of 30 years. Well, that age was lordship taken wrongly. If your lordship kindly come to judgment, just two paragraph I will read lordship. Page 43, the memo of appeal. My lord, page 43 of the judgment. Memo of appeal.
Yes.
Para 12, lordship. Now let us decide the quantum of compensation. As per para 12, page 43.
Page 43, yes.
Para 12. Now let us decide the quantum of compensation. As per claim petition and evidence of PW, at the time of accident, deceased was carpenter by occupation, and he was earning rupees 8,000 per month. But the claimant has not submitted any document in proof of income of the deceased. This being the position, national income of rupees 3,000 per month is taken into consideration, and thus the annual income of the deceased become 36,000. As per claim petition and evidence of PW1, the deceased has left behind him his wife and two minor sons as defendant. PW1, the claimant, in her cross-examination has stated the age of her elder son is 10 years and the younger son is 7 years at present. Her father-in-law and mother-in-law are not survived. Considering the number of dependents, 1/3 deduction is required to be made towards personal and living expenses of the deceased head
been living alive, and after 1/3 deduction, multiplicand become rupees so and so. So we are not questioning on that. It is stated that in the claim petition as well as in the evidence that at the time of accident, the age of the deceased was 30 years. This is important, Lordship. No age proof certificate has been submitted by the claimant. As per post-mortem report, Exhibit 5, the age of the deceased is 30 years. But the claimant PW1 in her cross-examination has stated that her present age is 35 years. And her husband was 4 years older than her. Considering the admitted piece of evidence, age of the deceased is taken into consideration 39. 35 plus 4, 39. And that was, Lordship, that on the basis of the cross-examination. Cross-examination was, Lordship, was done on 9/1/2024. Lordship, this date is important. 9/1/2024.
Okay.
And accident took place on 12/12/2009. So this 4 years, Lordship.
Accident on
12/12/2009. The 4 years difference is there. And she stated in her cross-examination that her present age is 35 years. So at the time of accident, she was 31 years.
12/12/2012.
12/12/2009.
2009.
That is the date of accident.
And evidence was recorded on
9/1/2014.
Mm.
4 years, 1 month,
Mm.
some days, 4 years, some days.
It will be
So in that event also,
highest will be 5 years.
so 31, 35 minus 4, 31. And again, Lordship, if we add 4 years above, her husband is older than her. So 31 plus 4, it will be 35, not 39. In that event also, multiplier would be 16. But they have taken 39 years, so multiplier is 15. That is not the exact position of the law. That is also not the exact position. As per Supreme Court judgment, Lordship, post-mortem date of age of the mentioned in the post-mortem report, that is to be taken into consideration. So as per post-mortem report, he was 30 years old at that time. I am relying, Lordship's judgment. Regarding post-mortem age on the date of as per post-mortem, your Lordship will find at paragraph 11. This is the latest Supreme Court judgment. Paragraph 11. The amount, may I read, Lordship? Arrived by the High Court of the monthly income of rupees so and so as against the claim of so and so appears to be on the lower side, and as the total earning of the deceased from family pension is so and so. Lordship, this is not important actually, Lordship. In the right side, your Lordship will find coming to the multiplier factor. Just 1, 2, 3, 4, 5, 6, 7 line. 7 line last 2 words.
Yes, I've got it. Yes.
Coming to multiplier factor, which is depend on the age. There is sufficient indication that the deceased was aged about 45 years as per post-mortem report, which is a scientific assessment of the age of the deceased. The purported discrepancy in the age with regard to that of the claimant and the deceased is erroneous for the reason that when the claim was filed, appellant number 1 was aged 30 years. And the difference of 15 years between the daughter-in-law and the mother-in-law cannot be said to be totally devoid of reality, given the contextual and prevalent societal norms in vogue at the time of marriage of the deceased, who would have been at 25 to 30 years prior to her death, in or about so and so. Moreover, in absence of material indicating, this is important, to the contrary, there is no inhibition to accept the age of the deceased as per post-mortem report. Thus, we incline to grant her the benefit of multiplier of 14, taking her age is 45 years. So this is the position of the law lordship. As per postmortem report, that age is to be taken. If that age is taken into consideration, multiplier would be 17. 25 to 30 years,
Okay.
17.
I have noted it.
Yes, now lordship, secondly, future prospect. No award is given in the future prospect. Your lordship is in the Punaseti judgment I have given.
No, see. Pronosticated judgment will not work. This case accident took place in 2009.
Yes, the Supreme Court judgment, your lordship, is always retrospective effect unless it is provided that it is prospective effect. Because
No, you cannot hold that it has been wrongly held in the year 2009.
we can say
No,
because
cannot.
we can rely lordship, your
We-
lordship.
Now we can add or anything we can do with any effect, prospective or retrospective. But that judgment is erroneous, you cannot say.
But that,
But not about postmortem report. Postmortem report is just correct.
yes,
That she should have relied on the postmortem report. It's okay.
my lord, that was the
Future prospects we will calculate. At that time, she will, whatever was available for her for the MSc court,
Yes.
MSCT court, that will be taken into consideration. That
may
time,
not-
pronosticated judgment was not in existence.
but yes, that was,
2009.
that was not there, so
Ah.
that may not be
So
taken.
it cannot be said that it's wrong.
But your lordship can take up this point because the Supreme Court judgment, your
It has
lordship.
to be wrong, erroneous. Then only I can set aside.
No,
Here, that calculation, age I'll take up.
erroneous,
This is always there. Scientific calculation of the age is always there. I will hold that the age is 30, but pronosticated judgment that future prospects cannot be taken and that
at that time, that judgment was not there, so
yes.
that was not taken. But your
Yes.
lordship, this is appeal. Appeal is the continuous cause of action. Your
So
lordship may take.
now you cannot say that that was wrong.
No, I will not say that judgment was wrong. That was not taken because the judgment was not there at that time.
Okay.
But your lordship can take this because Supreme Court judgment is always retrospective. Unless it is
Unless it is maintained,
Yes.
specifically mentioned.
specifically mentioned that it is prospective effect. So that benefit will come. So in that even lordship, 40% will come. Because he has a self,
Future prospect was calculated or not calculated?
not calculated,
Not at all calculated.
not at all calculated. That was absent. So I have given that Punaseti judgment lordship regarding future
Yes,
prospects.
yes.
And
Pronosticated judgment, I'll calculate the future prospects according to pronosticated judgment.
yes, paragraph 61, I have given lordship.
No, you have not given me pronosticated judgment.
Lordship, that is there. I have given you all this judgment. Lordship.
I have also
Yes,
copy.
yes.
It's para 61.
Okay.
And thirdly, lordship, loss of consortium. Only 10,000.
Hmm.
It should be lordship 40,000. Yeah.
According to pronosticated judgment.
Yes, as well as the lordship Magma
That,
General. Magma General hold that all the
So,
different
Vita Agarwal or what?
lordship
There's another judgment, no? Consortium relating to loss of consortium.
consortium that is also covered in the Punaseti judgment also under the head of consortium. There were lordship two son,
Hmm.
but claim petition was filed only mother.
Hmm.
As for Magma General lordship, they will also entitle, children are also entitled, but they are not claimant, your lordship, that is, I leave it to your lordship.
Hmm. Which
But-
one? Which judgment?
Magma General.
Magma General.
So,
Loss of consortium and future prospects, you are
Yes.
asking me to calculate according to pronosticated judgment.
Punaseti, that subsequent judgment is Magma General,
Hmm.
that whole,
Yes, yes.
that held that parental and
Hmm.
spouses, all,
Yes.
I have given that judgment
Yes.
also. And third, next lordship, loss of estate.
Where is the judgment?
Lordship make more than a
Oh,
like.
yes, yes, I've got it. Yes. All right.
Now Lordship loss of estate,
Loss of
no
estate.
award is given.
Okay.
So here it will be Lordship 15,000, now it will 16,500.
Mm.
Because it should be enhanced after every 3 years, Punaseti judgment. Now it will be more than 16,500. So 16,500, it will go under the head of loss of estate.
Okay.
And interest from the date of judgment. There are a lot of judgment lordship regarding interest.
Interest,
It
yes.
should be from the date of filing the claim petition. I have given the latest one judgment, Supreme Court 2025 lordship. This is in Niru, Niharika and others. Oriental Insurance and Niru, Niharika. This is the latest judgment, paragraph 7 and 8.
Okay.
So this is then lastly, lordship, income. Income of the deceased.
Yes.
Income of the deceased is very lordship, lower side is taken. He was a carpenter, that was not disputed. And
You have
on-
given this Sheikh Sadiq Sheikh judgment
lordship,
for a calculation
Yes,
of
yes.
income.
For
Skilled
it-
worker.
for income of two judgment I have given to that effect. One is lordship Sheikh Sadiq Sheikh Rafiq, paragraph 5. And another one is Mukesh Kumar lordship Chandra Elias versus Elias, para 9. 2022 1 HCC 198,
Para 9 years.
para 9.
And
And this much lordship regarding interest I have already given.
all right.
So all these heads lordship, the amount is to be awarded under this head lordship. And some heads lordship is very meager amount is given the income, and the interest is also only 6% from the date of judgment. It should be lordship 9%. Lordship.
May I, Your Lordship? So far, age and multiplier is concerned, it will be purely on the basis of the facts given in the case. If postmortem report says it is 30 years, we have nothing to say about
Yes.
that. So far, future prospect is concerned, in 2009, in no other cases it was considered by any court. Those who have not filed appeal, they have missed. Since they have filed appeal, they are telling that we are also entitled. But my lord, you think about so many other cases, 90% cases, they were satisfied without future prospect at that time. They have not come to higher court for claiming this. So this is not a matter of right that future prospect should to be considered in 2009. Because this pronunciatory judgment has come in 2017. So far, future, this conventional heads, this pronunciatory judgment can be considered. 70,000 is there, and enhancement after every 3 years, what he has said. There is nothing much to dispute. One thing I want to register my dissension that, so for the income considered, 3,000 is very meager and it is unjustified, he has said.
Yes.
I want to submit some documents, my lord. Central government revises national floor level minimum wage from rupees 100 per day to 115 per day, effective from 1/4/2011. So in 2009, this is applicable for Assam also, this particular. In 2009, skilled laborers, Assam government decided that the minimum wage should be 129 per day, skilled laborers. And in their case, they have claimed that he was a carpenter or mason or something, but there was no proof. So in such cases, Honorable Tribunal generally takes where there is no proof, it is unskilled and notional income to be taken as minimum wage. At that time, unskilled labor was 102 rupees per day. I have given papers. There is circular of Assam government. So this income was not baseless. Whatever the tribunal has considered is basing some facts from minimum wage act. So far, future prospect is concerned, my lord, Honorable Guwahati High Court has decided that if future prospect is considered, no interest to be considered on future prospect.
That is it.
There are many other cases also done by Supreme Court, decided by Supreme Court, future prospect, interest on future prospect is not considered. In Sharla Verma, the multipliers are decided and accordingly multiplier will be 16 or 17, whatever, as per the age of the deceased. Since this particular person was self-employed person, so if at all future prospect is considered, it will be 40% of income. And so for income is concerned, 3,000 is quite justified.
102 into 30 will not be 3,000.
Little
Somewhat
bit.
more.
Little bit more. That I don't dispute because minimum wage act is saying 102 something. So it will be something more. I don't mind if it is calculated as per the.
But not 10,000. But not 10,000.
Not 10,000 or 8,000 or something. And so for interest from the date of judgment is concerned, generally when tribunal used to give interest from date of judgment, when the claimants are very reluctant in submitting their evidence, they are taking 7, 8 occasions, then only they give the judgment. Since you are not interested to pursue the case.
Prolonging the case and then
Yes,
they are getting the
and
interest.
they should not be, nobody should not be rewarded for their own negligence.
Get the interest also.
Nobody should not be rewarded for their own negligence. That's why generally tribunal used to give interest from the date of judgment, because you are sleeping at the time of giving evidence. Now you are claiming from the date of filing. After filing, we can sleep for 10 years and interest will accrue. That is a situation when the tribunals are reluctant to give interest from date of filing. Generally, they give from date of filing, but in such cases only, they resort to give interest from date of award where the claimants are reluctant in giving their evidence in time and taking unnecessary dates and all. So
There's one judgment of this High Court.
6%.
Another bench. Date of giving adducing evidence. That time you became active, no? So
There
from
are
date of
judgments.
adducing evidence, then the interest is
The
calculated.
judgment what I have given, that Supreme
From
Court
this
judgment.
High Court,
Yes.
another bench, not me.
Supreme Court judgment I have given, that has very specifically says about the interest. My lord, if your lordship is, my friend is correct, maybe correct, lordship, if there was a fault on the part of the claimant, that interest may come from the date of judgment. But where is the fault?
I'll check.
Yes, where is the fault of that? There is
From
no,
the pillar code,
there
I'll
is
check
not
the
a single
records.
sentence, line in the judgment that it was a fault on the part of the claimant that he did not adduce evidence or take or took adjournment or so and so. Nothing is there.
So for deduction, 1/3 is correct.
Hmm.
What Honorable Tribunal has taken. and interest 6% at that time. Now it is 9% given by most of the courts, 8%, 7.5, 8, 9. There is no hard and fast thing.
At that time, everybody used to calculate.
It was
6%.
6% was there. That
Because
6% is
the-
there.
That was the interest of the.
Yes, everybody
next
got
one.
like this. So since they are in appeal, they cannot claim that 9% they should get. That judgment was right in giving 6% at that time, that point of time. So this is my humble submission, nothing much to dispute, only the
yes.
income is okay. And other things, whatever.
We'll have to calculate according to that Pranay Sethi's case. But now.
Just one thing, Lordship, regard one judgment of our High Court, I have given the judgment. Just one paragraph, Lordship, I want to give. On the other hand, the learned tribunal committed error in presuming that the claimant was having a monthly income of rupees 4,000. Whereas they specifically pleaded and deposed in the course
You
of
have
his
not
deposition.
given our High Court judgment.
This is a High Court judgment. Lordship,
I have it with me.
I have given that. No, this is the judgment of the Honorable Justice Suman Sen. Sorry, and Sodhi.
Late.
This is the first case, Lordship, you will have to do. Right, I have given that.
Oh, yes.
Paragraph 9 only.
Para 9, okay.
9.
Para 9, no?
9. On the other hand, the tribunal committed error in presuming that the claimant was having a monthly income of rupees 4,000. Whereas they specifically pleaded and deposed in course of his deposition on oath that his monthly income is rupees 7,000, 8,000 per month. The insurance company did not put any question to him in regard to his monthly income, and so there is no reason on the part of the learned tribunal not to believe the statement made by the claimant. The claim evidence, claimant's plea of having income of rupees 7,000, 8,000 has gone unrefuted in the evidence in absence of any challenge to that effect. The claimant was not challenged or contradicted by the insurance company when he stood in the witness box, and he had claim of having a monthly income of rupees 7,000 or 8,000. Under such circumstance, finding of the learned tribunal, the claimant was having monthly income of rupees 4,000 is held to be erroneous, and income of the claimant should have been accepted to be 7,000 per month.
Yeah, the LCR has to be consulted, whether cross-examination has been done by the opposite party insurance company regarding income, or insurance company was quite silent and happy.
Not regarding, my friend has relying some, this is not the notification of Assam government that 102 rupees per.
You can give the notification if I am wrong.
No, that is in the late worship, some papers.
No, no.
Late note, etc. That is.
Some papers I have not manufactured those
Those
papers. It is
circular-
from the website I have given. If you have any doubt,
2009 worship 100 per day.
that cannot be. That cannot be
How
is
can
your
be?
guess. I have given some tangible documents. You
It is
challenge it
possible.
by another document, notification. Otherwise, you don't.
100 per day.
If I am
2009.
guessing, you are guessing.
He was a carpenter. Your lordship is aware. What will be the amount?
I don't know.
No.
I don't know.
Manual work even also lordship. He was a carpenter. Minimum 500 rupees. was-
How to prove a carpenter? There is no license. I can claim that I am very highly skilled carpenter or mason or something, but where is the proof? Otherwise, he is unskilled only.
Yeah.
Notional means
You cannot
where-
expect that a carpenter can produce a certificate
why-
or order
why-
that he is a carpenter.
then some proof must be there.
So guess some, Honorable Supreme Court held that guess some is to be.
Then nobody will claim in the court that I am unskilled. Everybody will ask that I am skilled only. Who will come and claim that I am unskilled?
Have to rebutted the evidence that he was not carpenter.
You are telling that it is difficult to prove that he is
even-
carpenter.
even
It is
not a
equally
carpenter.
difficult to prove that he is not a carpenter.
Even if he is not a carpenter. he
That's
is
why this
skilled,
notional
and
income has
manual
come in.
labor, even that.
That's why
400,
notional
500 per
income.
day.
It is equally difficult not to prove that he is not a carpenter. That's why notional income, where there is no tangible proof.
Oh, this very meager amount. You are also aware, 3,000 rupees.
3,000 at 2009,
Yes.
brother. I am not standing in 2025, I am not telling that 3,000 is sufficient.
The lordship will see.
Lordship will definitely see, I am giving my points only.
Our duty we have done.
When the income is in 2009, it is 3,000, it will be taken care of by the interest.
Maybe.
If you want enhanced income, then forgo interest. That's all, Miller.
Our learned counsel, Mr. M. Khan for appellant and learned counsel, Mr.
A.N. Das.
A.N. Das for the insurance.
Respondent one, insurance company.
Respondent number 1, reserved for judgment and order.
Published.
Sir.
With your lordship. Because in this case, earlier year, I filed my written submission also, but I'll make oral submission. That's only fair to state that my written submission is on record. But in that case, I'll.
Written argument you have submitted.
Yes, lordship, but I have something more to add, more than the written submission. So I have, in this case, this appeal I have.
I don't have the written argument, I think.
Should be there, lordship, it's there. Seen it last time. Written argument.
Written argument asani.
In cross objection, lordship, the written arguments are there.
In cross, okay,
Cross.
okay.
There are
Yes, there's one
two,
more case.
yes, file a cross. Lordship, my case is this, lordship, the deceased was a bachelor. And the claimants in this case, especially in the claim petition itself, they are the married elder sisters of the bachelor. Married sisters. My ground of appeal in this case.
Two claimants?
Two claimants, both of them are married elder sisters. This raises, lordship, two very basic issues. First thing, whether they are entitled to compensation, that is one issue. And if so, how much? Entitlement of the claimants in this case is decided by the word legal representative. It's not defined in MSNP, but we go by the word legal representative definition in the civil.
Succession.
It includes lots of anybody, lordship. Anybody who was in some way financially dependent on the deceased. That is the law, legal representative. Therefore, the sisters being legal representatives, I have no doubt in my mind that they are entitled to claim compensation. One issue, that is in favor. But the second issue is how much they are entitled. Because dependency, lordship, is a very subtle, is a question of fact. They may be dependent, may not be dependent. If the same sisters were at home, not married, at home, and did nothing, and a brother used to go and earn for them, then clear case of dependency. But let's say, even in case of not just to speak of bachelor, but the brother, younger brother, even in case of, let's say, father, there is one case which is being still followed. Calcutta High Court did not allow anything to the married daughter because she was the only legal heir. Married daughter was not given anything. Matter went to Supreme Court. Supreme Court decided that they will be entitled to at least the no fault. So only 50,000 was given in that case. Manjuri Bara. That has been subsequently followed in other decisions also. It just goes on to show that a person who has claimed may be a legal representative, maybe he is entitled to claim compensation, but how much would be payable would depend on the facts and circumstances of the case. That's it.
Yes, yes.
Even very lately, also, our High Court has also decided a case on this issue. The married elder sisters will not be there. How much would be they would be entitled? That is again under issue. They will be entitled to something, not totally to strike them off, but how much will be decided is under issue. Here in this case, I'll go by some, I'll serially go by some decisions. First and foremost, I'll come to the decision of the 5-judge bench in Pranay Sethi. Pranay Sethi in turn has relied on a judgment of the Supreme Court, Sarla Verma.
Salavarma, para 30, 31, 32 have been quoted in para 37 of Pranay Sethi.
Yes.
That very clearly says that in absence of any evidence to the contrary, the siblings will not be considered as dependent on the bachelor. General situation, when a bachelor dies, the parents are usually alive. One of the parents or both the parents are alive. And in some situations, the only exception that is permitted, Lordship, in a case where the bachelor who died was also responsible for maintenance of a number of minor children, brothers and sisters. One case that has one real aspect of life that has taken. So that is the only exception that is permitted, that is discussed in the judgment itself.
Yes.
Para 31. It's very clearly. If there are minor children, etc., mother is a widowed mother. Example is given, says a widowed mother and several dependent children, brothers. That is the only exception permit with an example. Says, otherwise, siblings are not considered as dependent as a 5-judge bench. Now, to overrule it, there has to be under judgment by a bigger bench saying that no, all sisters and brothers would be entitled to compensation. That tantamounts to saying that sisters and brothers should be entitled to compensation irrespective of pay. Now, that means when the exception is relied upon, someone wants to say, oh, no, I am entitled to compensation on the basis of the exception carved out in that judgment. In that case, the burden would be on the other side. Prove it. Prove that in spite of being siblings, you were in some way dependent on them. Then it will be up to the court, Lordship, discretion of court to accept. Whereas this is a case which falls within the rule, siblings are not entitled, or within the exception that because of some situation that.
Yes.
So that is one situation, Lordship. In this case, Lordship, no such evidence was given. A claim petition itself is a cause title says married sisters. And as regards the compensation, there is no dispute because they had claimed as 3,000, the entire amount was taken as 3,000. So I'm not under compensation amount. What I'm on is, Lordship, how much of that compensation is there entitled? One I have already discussed, Lordship, Pranay Sethi. Recently, Lordship, there has been one under judgment of the Supreme Court. Older married siblings are, Lordship, older married siblings are generally not considered dependents for compensation claims. This is judgment by Honorable Justice S.K. Roy and Sanjay Karal. Older married siblings. There is yet another judgment, Lordship, of the Honorable Guwahati High Court, Lordship. Donald Bench. Okay.
You are the insurer?
I'm right.
So there are two cases. You are for the insurer in both the cases.
Lordship?
There are two cases now here.
Two cases. I'm the insurer in
You
both
are for the
cases.
insurer.
That's it. This is the judgment of Guwahati High Court, Lordship. Cross objection.
This is same. Older married siblings not entitled to
Yes,
compensation.
that's the judgment of the High Court, Lordship.
Yes, yes.
Of our High Court. That's it. Our High Court has relied upon this judgment of the Karnataka High Court, which is widely followed in Yellow. So as this is one of the best judgments on the concept of loss to estate. Lots of compensation is envisaged on when a person dies. There can be two consequences. One is the loss of dependency suffered by the family members. Suppose in a case, Lordship, there is no loss of dependency. Then that is the case when it is governed by the loss to estate, the concept of loss to estate. How much he would have saved and how much would the legal heirs would have inherited. Regardless of Lordship, he might brother might be a very rich man, is not dependent, but when the brother dies, other brother dies, he's the legally, only legally. So he gets whatever is saved in the banks and all. That's a loss to estate. So these are two concepts also which govern the field of compensation. It's either when a person does, the consequence either someone suffers a loss of dependency or no one suffers a loss of dependency, but then estate suffers a loss. That means accretion to the bank account or whatever it is has stopped. Property has accretion to his estate has stopped. That is the two kinds of losses. So that our High Court has followed this decision also. A Manavalagam. That's very clear. I have marked in red, Lordship may see that particular page which I have folded marked in red. It says very clearly. It discusses when this particular issue, when the siblings are here. They said it has taken a 15%. That much a person has no care in the world, no one to look for, no one to support. He spends whatever he earns and maybe 15% is saved. That will go into his account and legally I shall get it. This is that particular line, Manavagalam, the red part, that is very clearly. It has discussed various issues, Lordship. Like husband and wife both are educated and both are earning. There can be two situations. One, they live together in the same station, or maybe they work in different stations, they live there. So what is the impact of living together and living separately? Separately means they both have to maintain distinct households, maybe assistance and whatever is it. So there the savings should be less. But when they live together, everything is, they can divide everything by 2 and savings is more. So in that case, how much should be they are not dependent on each other. They might be both very highly well-placed individuals in life. So in that case, but they both save in the process. So that will be governed by the concept of loss to estate. No dependency, but loss to estate. When the one dies, the other gets the benefit of the loss to estate. Now, so in this case, because there is a violation of the policy condition by the owner of the vehicle, the pay and recovery has been given because this was insured as a private car. And it was used as a commercial vehicle. The facts very clearly established themselves. There is a violation of policy condition. So insurance company has been directed to pay. And then
it was a private vehicle used as commercial vehicle.
It is used as a commercial, it is used as taxi loss.
Taxi. But bought as a private vehicle used as a taxi.
Yes, yes. Insured as a private vehicle, used as a, and there is no dispute, it was not disputed at lower courts also. So I'm not raising it is because whatever is the outcome of today's case, Lordship, I'll be able to recover it from the owner of the vehicle. Owner of the vehicle in turn was not present before the tribunal to defend that vehicle was not used as a taxi but was used as a private car. That defense was not there before then. We in fact proved it and was given the benefit of pay and recovery. So this is my, I've relied on chronicity, relied on judgment of the High Court. And regards, I'll not go into the issue, but if it helps, Lordship, to understand the concept of the dependency, this judgment of Manjiripura relied upon by High Court. This is a case of father and daughter. Here we are in a case of brother and sister. So, but still I'm giving this, Lordship. This, this has again been followed by under judgment same way, Deepshikha versus Nasenso. It says married daughters. It's a very peculiar case, Lordship. In this case, the lady who died has left behind the mother, elder mother, 70-year-old, and a married daughter. Only Supreme Court decided 19,22,000 was given to the mother. And the daughter was given only 50,000 because she is married, has a husband to support her. This, they are both related in some ways. I mean, just to help Lordship to understand the concept of loss to. This is my case, Lordship.
I'll go through it.
Oblige.
My primary issue is,
You are
is that
the-
I am for the claimant, respondent number 1 and 2.
Respondent number 1.
1 and 2.
Okay.
Lordship, first of all, Lordship, the ground what my friend has taken,
Yes.
that
They are
sisters,
married daughters, yes.
married daughter, they are not entitled.
Married sisters.
Married sister,
Hmm.
they are not entitled. Whether that plea was taken before the tribunal or not, this is important question.
Yes, yes.
My lord, in the written statement, there is no any whisper that the daughter, sisters are not entitled because they are not dependent. In appeal, first time they, Lordship, they have raised that issue, which is not maintainable in this appeal, the new ground.
Okay.
My lord, I have given a set of judgment that your Lordship will find it, I think, in the cross objection. Set of judgment, Lordship, started from one judgment 2020, 11 HCC 356. And before that, Lordship, one judgment.
Yes.
Lordship, first of all, Lordship, I will rely on judgment that is 2002 HCC 734. That is there, Lordship, paragraph 10.
Yes.
May I read, Lordship? Only one paragraph. We may refer to the next ground on which the appeal has to be allowed. It is a settled position of law that in an appeal, the parties cannot urge new facts. From the pleading of the respondent before the State Commission, it is found that the respondent pleaded that the property damage was not covered under the insurance policy. This plea was given a go by before the National Commission, and a new plea was taken up in the grounds of appeal that the terms and condition of the insurance policy were violated by the appellant by using used clean furniture. The National Commission accepted this new ground and allowed the appeal, which is, in our opinion, is not sustainable in law. So this is new ground in the appeal should not be accepted, and other Lordship judgment. Should be the first case, Lordship. Tata AIG General Insurance Company Limited, paragraph, Lordship, 15 and 18.
Okay.
This is reported judgment, Lordship, 2000. I have cited the judgment 2025 for GLR 817. Paragraph 15. This court has considered the opposing submission of the learned counsel for the parties and perused the judgment relied upon, as well as the LCR of MSC so and so. Issue that need to be decided by these courts are whether a new ground can be raised in appeal when the same was not raised before the tribunal. My lord, this answer is given in paragraph 18. 18. In view of the settled position of law as laid down by the Guwahati High Court in case of so and so, the Honorable Supreme Court's Hindustan so and so, it is decided that new ground cannot be urged in the appeal when it was not raised before the tribunal. The argument pertaining to force insurance policy is therefore not sustainable in law. The first issue is decided against the appellant insurer. So this is one judgment, and another your Lordship will find 2024 4 GLT 574 para 9, Lordship.
Yes.
It is insofar the issue of permit is concerned that it is true that section 66 of the MV Act so also prescribe about the necessity of permit. As per section 66 of the Motor Vehicle Act so and so, no owner or of a motor vehicle shall use or permit the use of a vehicle as a transport vehicle in any public place, whether or not such vehicle is carrying any passenger or goods have in accordance with condition of the terms of so and so, so and so. Countersigned by the so and so transport authority or prescribed authority authorizing him the use of the vehicle in the place and manner in which vehicle is used. Evidently, the subject vehicle is transport vehicle which was used for the purpose of carrying goods. When a query is made to the learned counsel for the appellant as to whether the lack of permit in respect of the subject vehicle was a ground taken in the written statement. He in response has submitted that lack of permit in respect of vehicle, subject vehicle was not specifically taken as a ground in the written statement filed on behalf of the insurance company so and so. It is noticed that owner had also filed his written statement stating the subject vehicle was plying with all relevant documents, driving license, insurance, so and so. When the deposition of the claimant witness are perused, it is noticed that the claimant sides so and so were cross-examined by the owner and the insurer of the subject vehicle in the proceeding before the tribunal, but neither the claimant number 1 nor the eyewitness was cross-examined on the point of lack of permit in respect of the subject vehicle to ply on the route where the accident took place. Had the issue of lack of permit on the part of the owner of the subject vehicle was taken by the appellant insurer in his written statement, it would have been possible for the owner of the subject vehicle to traverse the point and to adduce evidence as regard the availability of permit for the subject vehicle or otherwise. It was urged on behalf of the appellant insurance before the tribunal that the subject vehicle had route permit only for so and so, did not have route permit to ply in the state of Assam. The learned tribunal discarded such contention on the ground that the insurer did not prove the same by producing the route permit. It is not open for the appellant insurer to raise a ground for which the foundation has not been laid in the proceeding before the tribunal. Had the issue of lack of permit had been taken by the insurer by laying proper foundation before the tribunal, by taking such a ground in the pleading and thereafter by adducing evidence and the points was decided against it, then it might have possible for the appellant insurance to take such point in appeal. With nothing such done, it is not open for the appellant insurer to hesitate the issue of lack of permit at the stage of appeal with no tangible material available in support of such claim. This court does not find it acceptable. So this is the law point lawsuit that has been raised before the learned single judge that was rejected. And another judgment lawsuit in Sikkim High Court judgment I have given, that is same thing lawsuit that relying some judgment, the court held that plea cannot be taken in the appeal. So in that kind of lawsuit, this lawsuit appeal should be dismissed, because this is purely on knee ground. There is no whisper in the written statement as well as in the evidence. That point was never raised.
Okay.
And so for the other issue regarding the
Pay and recovery.
pay and recovery, that part I have nothing to say. That part my friend will say. And so for maintainability regarding the entitlement, I have given some judgment lawsuit, that is a set of judgment. In all those judgment lawsuits saying that for filing a claim petition, dependent is not necessary. Only legal representative, as per provision of the MB Act, can file a claim petition. And since the award that
Legal yes can file yes.
yes, I have
It is
given
there.
the written argument also. All these things I have stated.
But he is not staying about submitting.
I'm not disputing that.
He is not disputing that point. He is disputing on some other aspect.
So my point is that point was, as that point was not taken before the tribunal, that should not be accepted.
Yes, yes.
This point. And other points, answer I have given lordship in the written argument, your lordship will find, and judgment so you also given.
You have also given a written argument.
Yes, my print has also submitted.
Yes.
There is just one point I'd like
Written
to add.
argument to আসেনি বা আমার দেখা নাই। Oh yes, yes, yes. I've got it now.
I just like add one point to it.
Oh, you'd like to
In the
reply?
claim petition, lordship, this claim petition is not filed as a dependent. There is not a single word sentence that says the claimants were dependent in it. Not a single word about the word dependency does not appear in the claim petition. Brother is to earn 3,000 rupees per month, so we are entitled to so much. It's a claim petition for entitlement. Not a single word, Lord, say, I have gone through the entire claim petition, I have marked in red.
That
Not
was
a
the golden
single
opportunity
word
of my
that
friend
they
to
have
raise that
suffered any
issue.
loss of dependency.
Before the tribunal.
It's just a claim for entitlement. It's not a case of dependency. It's a case of entitlement that since the brother had
How much
worked.
you are asked to pay? How much is the owner asked to
3
pay?
lakhs.
Mhm.
3,49,000. My lord, I in pros objection, Lordship, I filed for enhancement of this award. Because here, Lordship, only here is also 3,000 is taken. He was a driver. Deceased was a driver and only 3,000 Lordship per month. That income was taken into
No,
consideration.
that was the entire amount claimed. Also. 3,000 was claimed and tribunal very liberally consider 100%. Now he cannot make up a case for 6,000 per month. After so many years. At that time, that was the claim. 3,000, it was allowed. So I have not raised it as a.
And
He cannot make a new
And
ground.
interest part, Lordship, only 6% interest is given. Here from the date of filing of the claim petition. Yes.
Owner of the
I
vehicle
am for the respondent number 3, owner of the vehicle.
is
Lordship.
the worst sufferer.
While fully supporting the case of the insurance so far, their claim petition, not entitlement, except this 50,000 part. Not a single whisper, neither in the claim petition nor in the evidence, that we are the dependents on in any manner. Not a single whisper is there. That in any manner we are dependent on our brother. So I have just one part to oppose to the insurance company is the pay and recover part, Lordship.
Definitely.
Before that, Lordship, I am just pointing out in the trial court record, if your Lordship goes to the order dated 2709, an order was passed on 13/5/09, showing a summon was served on the husband. But in fact, summon was never served on the respondent number 3.
Okay, this 2709.
It is the order dated 13/5/09,
13509.
13/5/09, and then no order was made on that day, Lordship. Expert order was made on 2709. It is the first page of the trial court record, Lordship, in the order sheet and the backside page. So I would like to just raise the CPC order 5 rule 9 before filing an expertise, proceeding expertise. Learned trial court has to record a satisfaction when an acknowledgement, the court issuing the summons shall declare. This is the mandate of the law, Lordship, that summons has been duly served on the dependent. There must be a declaration. That has never been there. Simply send report received. Next date, case shall proceed expertise. When the case shall proceed expertise is guided by order 9, rule 6, sub rule A. When summons duly served, if it is proved that the summons was duly served, the court may make an order that the suit be proceed expertise. No such satisfaction was ever recorded. I am raising this only on a context, Lordship. I have got two options. Either I have to go to 913, setting aside of the expertise judgment, which was passed against me, or now before this appellate court, I have received the notice from this appellate court and came to know about pendency of this case, judgment against me, and the pendency of the appeal. So I am preferring, Lordship, one point here, that under order 41 rule 33, being in first appellate court, your Lordship has ample powers to look into these matters. In this context, Lordship, I would like to place, parallelly there was a consumer case on the same accident, where we have put our pleadings. So I would like to a judgment that has been disposed on, and two judgments on this 41, power of this honorable court as a first appellate court on 4133, order 41 rule 33 of CPC.
Okay.
So consumer case, Lordship,
There's a little bit of glitch here because you see, we can make any rules and then CPC not required to be followed.
that is, I agree, Lordship. I fully agree on that, but I am coming on that context, Lordship. This consumer case we have filed on 2/2/2010. During pendency of this MSCT appeals, insurance company is contesting that consumer case. I am coming to the fact of our case. So they are fully aware that there is a parallelly consumer case, and in Bongaigaon, practically, Lordship, Honorable District Judge is the chairman of that consumer court. They are contesting that consumer court. That has never been pointed out either to us or to the court, that the owner is contesting the consumer court for the same vehicle. I'm coming to the facts of that. I just placing this tool. That consumer case has been disposed in 2025. Now they have insurance companies preferred an appeal before our state consumer forum also. In this case, we have pleaded our case, Lordship, which had we been summoned, we could have pleaded in the MSCT appeal, MSCT case also. Our case is that on that day, the driver, the deceased, took the vehicle with permission for attending his ailing family members. Their case is that the driver took the vehicle to the motor stand, carried the passengers. That was never under instructions from the owner. It is on his own. So there cannot be any violation of policy conditions. What as held by the member MSCT, that there is a apparent violation. We have never instructed the driver to use the vehicle on a higher basis.
You did not get the scope to prove your case.
That's it. That's why I have given this, because we have pleaded that case, our case in the consumer forum. Our base, this is a case where driver was murdered. He has taken 2 persons or 3 persons. They have taken the vehicle with the driver, killed the driver, thrown the dead body in the coconut farm of Vayapuri, and then vehicle was taken away. Commission of the theft of the vehicle. Dead body was recovered by the coconut farm staffs. FIR was lodged by them. On the next day we are called, we have identified the driver.
This same vehicle?
Yes.
Same vehicle?
Yes, this is the case, Lordship. Vehicle was theft. This is not a simple case of accident, Lordship. Here in this case, the driver was killed by the so-called passengers. His dead body was recovered on the next day in the coconut farm. FIR was lodged by the staff of the coconut farms. The next day we are called, we have identified that. We have put a claim before the insurance company for theft of the vehicle. There was a dispute regarding the amount they have, and on not being satisfied with this claim, what the insurance company offered to us.
But why it has come as an accident case here?
That's why I am coming, Lordship. I am coming on that part, Lordship. We are not contemplating even. We are under the impression that there is a murder case, 302 case. They will go for the victim compensation scheme, get the amount. So we have never searched for that. At the best, there may be a worseman compensation part. So we have never searched for even this MSCT tribunal website, etc., that there may be any claim compensation. We are under the impression either there will be a WC case.
This is the same case.
Same case.
I'm really surprised. How it has been misunderstood to be an accident case?
Not say it's a claimant's case, in fact.
It is the claimant's
said
case.
in our affidavit, that vehicle was in the taxi stand. When a vehicle is in taxi stand, implication is for her.
Even if
And
that
2
is,
persons boarded the vehicle and they killed him. So in para number 15 of the judgment, Lordship, see, the learned member has discussed this and came to this was obviously a case where the vehicle was used. That's a separate proceeding. We are not, I don't know, at that point of
No,
time.
see, I'll not rest this case today here. I will ask questions. I'll ask questions.
so my point is, Lordship, that had we get an opportunity to file our WS, we could have, whatever in the 2010 Lordship itself, we have placed our plea in the consumer case. So on this context only, I request the Lordship to go through that judgment, whatever the plea we raised, and to decide.
So you want to go back to trial court and then court?
No, we have one option. Without going to that option, we are requesting the Lordship to exercising the power under 4133 to at least remove that part only of the judgment, pay and recover part. That is within the power of this court. I have given 2
I have to
judgments.
see that judgment. I was not aware of this particular proceeding.
Yeah, I'm really surprised.
So that
An
has-
accident case turned out to be a murder case. Really, I'll have
That is
to.
not an
It's a
accident
murder
case.
case.
That is not an accident case. This is a murder case, Lordship. Murder of the driver.
And the sisters are his.
They are the simply claimants.
Okay.
They
are
have
and
filed the claim
sisters.
on the murder of their brother.
In fact, it is their allegation, Lordship. That two persons hired the vehicle and then killed her. That is the case.
So my submission is,
It's not an accident like
Go through.
it has gone and hit something like it's not an accident
You
like
just
this.
go through this judgment, both of
this
you.
4133 is a general power, Lordship.
But before that, Lordship, I have one submission.
167, they have got
I don't know under what basis my friend is submitting, whether he has filed any appeal before this honorable court against that of judgment. He is arguing against the appeal filed by the insurance company.
Correct, correct.
He should have Lordship filed an appeal against that judgment. He has not filed. How he can argue that he was not given so and so, so and so? He cannot.
In fact, it's been a different.
That is a point. That's why this judgment was given.
There will be a cross objection also for that.
He has a grievances. He should have raised before this honorable court by filing appeal. He has not filed appeal. How he can submit in this case that he is not liable and so and so? He cannot.
The remedy
You have
was in,
point there.
And another point, Lordship,
remedy was in filing an appeal against the order of the tribunal.
I am on that line, Lordship. The judgment of this honorable, our Guwahati High Court, Lordship. I have given the copy, Lordship. Para 20, plain reading of aforesaid 4133
Which one?
makes it clear. Appellate court is empowered to make whatever order it thinks fit.
That is there.
So, in this line, in an appropriate case, even grant of a decree, even a party to the appeal who could have filed the cross objection under 4122. Here in this case, Lordship, I could have filed a cross objection.
Which judgment are you reading? Fidaul Haq and Raju.
This is Faidul Haq.
Okay.
Faidul Haq. I have given the copy, Lordship.
Okay. And Raju.
That is also same Ranjana.
And who has given this judgment?
I have given two judgments, Lordship.
Ranjana Prakash.
Ranjana
and
Prakash
others?
judgment.
You have given.
Same thing. Honorable Supreme Court has stated. Without filing a cross objection under order 21, under 41 rule
There is
22.
cross objection here.
No, they have filed the cross objection. I have not filed. Once they have filed the cross objection, my right to object again starts. Once they have filed the cross objection for enhancement, my right starts without filing even any other cross objection. Oppose them. So here,
Para which para?
para 20, Lordship, in the case of this is Faidul Haq. Here it is stated. Even a party to the appeal,
Faidul, okay, para 20.
even a case who could have filed a cross objection under 4122 has not done so. A reference in this regard may be made to the judgment of the Apex Court in Pannalal State versus AIA 1963. Without filing a cross objection, because I have a limited what they are submitting, I am accepting it. Yes, claimant has not entitled for any claim on dependency, except this no fault liability part. So my only submission is this pay and recover part. So for that, I could have filed a 4122 petition, cross objection to remove that part. But without filing that part, I can, under Honorable Court has the power under 4133. These two judgments are on the same line regarding the necessity of 4122. Here I have given the consumer judgment only to bring on record to this context that what was the case of the owner. That vehicle was stolen away. He has taken the driver, if at all believed their case, vehicle was taken to the stand and passengers were carried without the permission of the court of owner. So owner cannot be held negligent or violating the policy condition. This is only my limited submission.
I'll need a copy of that because judgment and 25.
So you
My they did not know about it.
They have preferred appeal. They have preferred
now
appeal to the state forum.
this burden. If
Yes.
I call for this, then again I
Every
have to accept
day,
this as evidence. So I will not take this burden now.
They have preferred an appeal even state forum, Lordship. Against this judgment of consumer forum. Insurance companies preferred an appeal, Lordship. Recently, I have received the summons and I have submitted my WS as your owners. So my submission is this much of limitation. Only to remove that part of pay and recover part. Whatever the amount, let the insurance company, they are entitled for 50,000. I agree
So
that
how
part.
can I take this into consideration.
This is because of that summons was not served. Only on that context. To what is the case?
No,
Only on that
uh,
context, nothing more than that part.
No. Maybe your submission relating to recovery or pay and recovery maybe can be taken into consideration.
That is only on
But
that
this
context,
argument
only
without
simply
any-
what, because it is a case of 2010 lordship. I am not taking a new plea. Case is of 2008, accident is of 2008 or 2009 most probably, 2008 or 2009. During pendency of the MSc case, we have filed this consumer case. Just only for that, yes, there is a case of theft. This is not a case of murder. Sorry, this is not a case of simple accident. Only to that context.
Only accident is what lordship, apart from that use of the vehicle. If your lordship kindly come to section 165, it is not a case that only on the basis of the accident, a claim case is to be maintainable. But only use of the vehicle.
He is a driver.
Use of the vehicle.
Cannot say use of the
In
vehicle.
that even also in murder,
you see,
accident, whatever may be.
This is a consumer forum's judgment, judicial notice also can be taken.
Definitely lordship.
But
I have simply,
how is
simply I have brought it only to the bring the facts. Yes, there is a some, had we been given the opportunity to file our WS, we could have bring this plea.
On
That much
basis,
only,
we
nothing
should
more
have
than
filed
that. Nothing more than
Cross
that.
objection, whatever may be. He has not filed.
No, I don't know. See,
He has
judicial
withdrawn.
notice also can be taken because this is a judgment of a consumer forum. Quasi civil court.
Assembly आपने पता extra कर दिया।
So I'll not raise this case here. I'll hear one more day on whether I can accept this case.
So this is simply because not for accepting lordship. I am only on the power of this honorable court under 4133. Only on to exercise the power, I am
No,
calling
I have
upon
to
this.
ask question.
That will in that case require our submissions on that particular
And
judgment.
if
rightly,
otherwise, Lordship,
wrongly,
if
whether
otherwise-
tribunal has correct-
It's a copy, I'll be.
No, if otherwise lordship, 4120 say no limitation, court may direct me to file an affidavit with this judgment. I can bring on record on that line on either on a form of cross objection or on the form of an affidavit. That may delay the case, that's why.
Permission of the court is not required. He has got the notice. After that, he can file a cross objection. He did not.
That is not a mandatory part. Cross objection is because my prayer is very limited, not mandatory. 4122 is not mandatory. That's why I have given these two judgments, Lordship. Only to show that 4122 is not mandatory, even court can go on that line.
Hard question, sir. Hard learned counsel, Mr. R. Goswami for the insurer. For the insurer, এনেকে লিখি দিলে ভাল হ'ব. Learned counsel, Mr. M. Khan for the.
Respondent number.
No,
One and
no,
two.
not respondent, for the claimants.
For the
Because we have two cases here.
Two cases.
two cases, the
And
first
learned counsel, Mr. S.K. Poddar for the
respondent 3 owner,
owner of the
vehicle.
allegedly offending vehicle or owner of the vehicle.
Number.
আৰু এটা দিন দি দিও. You go through the judgment and you submit whatever you want to submit, or only one single point, it boils down to the judgment.
I can give.
And it's on the Thursday lordship.
Yes, only it boils down to only this judgment and then we'll fix it for order. Yes, 16 September.
That's
This
part of
this
the-
matter on 16 September as part heard.
কিমান দিলে?
Earlier, somebody had it and released it from part heard.
Long time back, lordship it was.
Maybe because of these complications. এইটো ইয়াত দিয়ে rejected at this stage.
Item number 11 for hearing.
Make decision, Lordship. Lordship, basically, we are aggrieved by the fact that there was hidden collision. The court has not considered that. And the calculation is not correct. Miss allowance is added. Then Lordship, that income, Lordship, which was taken as 33,728 per month. The income which was taken as 33,728 per month. Income tax was not deducted from that, Lordship.
33,728
7 per month,
but income tax was not deducted.
not deducted.
Okay.
And mother of the deceased was not part of the family. So, Lordship, that deduction towards personal expenses ought to have been 1/3. Mother was staying with another son. Okay. Instead of 1/4. Lordship, I'll just read the judgment, Lordship, so that the facts are clear.
Okay.
Lordship, the judgment, Lordship, starts at page 7 in my memo of appeal, Lordship. The present claim case has arisen out of a claim petition filed under section 166 of the MBR claiming compensation on account of death of Deepak Kumar Sharma in a motor vehicle accident. Srimati Rima Kaushik Sharma, wife of deceased, Srimati Bhanu Sharma, mother of deceased, Miss Suranjana Sharma, daughter of deceased, and Sri Ishant Iman Kashyap, son of deceased, are the claimants. The daughter and son of the deceased, being minors, are represented by the mother, Srimati Rima Kaushik. Lordship, before I start, one thing I want to say, already 50% was deposited and they have taken it. The case of the claimant in a nutshell is that on 5/12/13 at about 11:30 a.m. while the deceased Deepak Kumar Sharma Sharma came out of his home by driving motorcycle bearing number so and so on the left hand side of the road in a slow speed and to go to his place of work, suddenly another vehicle bearing registration number so and so came from opposite direction, Lordship. This I would like to highlight, opposite direction. So there was a head-on collision between the vehicles, admittedly. And the driver of the vehicle was using his mobile phone at the time of accident. Lordship, in the FIR, there is no mention that the driver was using his mobile phone. FIR I have also annexed. I'll read that also. With the with my memo of appeal, I have annexed that FIR, Lordship. This is, and the translated copy also have been. By seeing the motorcycle bearing number so and so coming from opposite direction in a rash and negligent manner, the deceased Deepak Kumar Sharma took his motorcycle on the extreme left hand side of the road and almost stopped his vehicle. But Rajumoni Bora, who was driving the vehicle number so and so in a rash and negligent manner, came to the wrong side of the road, leaving his left side, resulting the accident. As a result of the accident, deceased sustained grievous injuries on his person, including head and chest. Immediately after the accident, deceased was brought to Kopili Hospital and then to BP Civil Hospital, Nagaon. And thereafter, the deceased was taken to Dispur Hospital, Guwahati. The deceased was kept in the hospital from 5/12/13 to 3/1/14 in ICU, and at last he died on 3/1/14 at 11 a.m. at Dispur Hospital. It is alleged that the accident took place due to rash and negligent driving of the driver of the offending vehicle bearing number so and so. The claimants in their claim petition have pleaded the owner, driver, and insurer of the vehicle involved in the accident. The OP number 1 and 2, owner and driver of the vehicle number so and so, contested the case by filing written statement and contended inter alia that the claim petition is not maintainable and there is no cause of action. The OP also denied age, income, occupation of the deceased as alleged in the claim petition. The owner of the vehicle has stated that at the time of accident, the vehicle was duly insured with National Insurance Company Limited with policy number so and so, which is valid on 5/3/14, and in case any liability is fixed upon the owner, then he should be indemnified by the above named insurer. The OP number 3, National Insurance Company, the insurer of the vehicle number so and so, in their written statement contended inter alia that there is no cause of action. The claim petition is bad for non-joinder of necessary parties. It is submitted that the driver of the vehicle had a valid driving license at the relevant time of accident, and hence the company is not liable to indemnify the owner. Rash and negligent driving on the part of the driver of the vehicle is denied. Lordship, this will be our in our returns. From there, we started with. The insurance company denied the age, income, occupation of the deceased as alleged in the claim petition. In fact, Lordship, the driver, Raju, what is his name? He had filed another FIR also, but since the deceased was Raju Moni Bora, since the deceased was dead, Lordship, so the case, because the other vehicle, Deepak Sharma died, Lordship, so that case was, resulted in final report, FR, Lordship. But he had filed one FIR, that rash and negligence of Deepak Kumar Sharma. Upon the pleading of both sides, the following issues are framed for adjudication of the case. Whether the claim petition is maintainable, whether the accident occurred due to rash and negligent driving of the driver of vehicle number so-and-so motorcycle, whether the claimant is entitled for compensation, if so, what reliefs the claimant is entitled to what amount the claimant is entitled to, and who will be liable to pay the amount. Decision and reasons thereof. Issue number 1. The claimants have filed this claim petition under section 166 of the MP Act claiming compensation for death of Deepak Kumar Sharma, who is the husband of claimant number 1. In the claim petition, she has implicated the owner, driver, and also the insurer of the vehicles which were involved in the accident. The evidence of claimant number 1 is that the incident occurred due to rash and negligent driving of the driver of the vehicle number so-and-so, and that as a result of the accident, her husband died. There is nothing in record to show why the claim petition is not maintainable. Accordingly, this issue is decided in affirmative in favor of the claimants. PW1 Srimati Rima Kaushik Sharma testified that on 5/12/13 at about 11:30 a.m. while her deceased husband Deepak Kumar Sharma came out of his home by driving motorcycle bearing registration number so-and-so on the left side of the road in a slow speed to go to his place of work. Suddenly, another vehicle bearing registration number so-and-so motorcycle came from opposite direction, and the driver of the vehicle was using mobile phone. Lordship, this part, Lordship, I'll show from the FIR that this is a improvement in the court, because in the FIR there is no mention of any mobile phone at the time of an accident. And moreover, Lordship, this wife was not an eyewitness to the accident. So mobile phone, how she knows about any mobile phone being used? She disclosed that by seeing the motorcycle bearing so-and-so coming from opposite direction. So Lordship, this opposite direction is coming again and again. In a rash and negligent manner, her deceased husband, Deepak Kumar Sharma, took his motorcycle on the extreme left side of the road and almost stopped his vehicle. But Raju Moni Bora, who was driving the vehicle number so-and-so motorcycle in a rash and negligent manner, came to the wrong side of the road, leaving his left side, resulting the accident. She disclosed that as a result of the accident, her deceased husband sustained grievous injury on his person, including head and chest. Immediately after the accident, her deceased husband was brought to Kapili Hospital and then to BP Civil Hospital, Nagaon. And thereafter, her deceased husband was taken to Dispur Hospital, Guwahati. She disclosed that her deceased husband was kept in the hospital from 5/12/13 to 3/1/14 in ICU. And at last, he died on 3/1/14 at 11 a.m. at Dispur Hospital. It is alleged that the accident took place due to rash and negligent driving of the driver of the offending vehicle bearing registration number so-and-so motorcycle. She has submitted Exhibit 1 Accident Information Report, Exhibit 2 to 8 a certified copy of charge sheet, FIR, seizure list, MBI report, etc. MBI report, Lordship, in that also the damage to the vehicles were in front. So there was a head-on collision. Exhibit 9, postmortem report. Exhibit 10, salary certificate. Exhibit 11, certificate of cause of death. Exhibit 13, legal hour certificate. Exhibit 13, again, birth certificate. Exhibit 14, driving license. And Exhibit 15 to 150, prescriptions and cash memo. Lordship, about this also, I have a ground. These are all photocopies, Lordship. The deceased was the deceased was working in the police department, Lordship. So maybe he got his medical expenses. That's why all these documents were photocopied. And Lordship, medical expenses the court gave is 5,80,000 based on these photocopies. I'll submit a written argument, Lordship. In that also I have mentioned from the LCR, Lordship, what are the documents which are which are photocopies. Let's see. Exhibit 226, 9, 11, 13, page 207. I'll first let me finish the judgment. I'll go to the argument later. However, during cross-examination, PW1 admitted that she did not witness the occurrence, but she arrived at the place of occurrence after the occurrence. PW2 Chandra Kumar Ray, who claimed himself to be an eyewitness, disclosed during his evidence that on 5/12/13 at about 11:30 a.m. when he was at Amtol Path, Dimoruguri, and at that time he saw a vehicle bearing registration number so and so being driven by Deepak Kumar Sharma on the left-hand side of the road in a slow speed, and at that time another motorcycle bearing registration number so and so motorcycle came from opposite direction in a rash and negligent manner using mobile phone coming on the right side of the road and knocked the motorcycle number so and so, which was on the extreme left side of the road and was almost in standing position. He disclosed that as a result of the accident, deceased Deepak Kumar Sharma sustained grievous injuries on his person and died after about 1 month of the accident. It is alleged that the accident took place due to rash and negligent driving of the driver of the offending vehicle bearing registration number so and so. During the cross-examination, this witness thoroughly yet could not assail her evidence regarding rash and negligent driving of the driver of the offending vehicle for whose fault the accident happened. On careful appraisal of the testimony of the eyewitness, PW2 Chandra Kumar Ray, who claims himself as an eyewitness to the occurrence, it appears that he clearly revealed that the accident happened due to rash and negligent driving of the driver of the vehicle bearing registration number so and so. His appearance at the place of occurrence is found to be quite natural. The OP could not disclose the testimony of PW2 regarding the above fact. He reiterated that the accident took place due to rash and negligent driving of the driver of the vehicle bearing registration number so and so. The insurance also did not adduce any evidence in rebuttal to the testimony of the eyewitness. Exhibit 1 accident information report shows that the case being Nagaon PS case number so and so was registered by Nagaon PS regarding the accident caused by the driver of the vehicle bearing registration number so and Deepak Kumar Sharma was shown as the ill-fated person who succumbed to his injuries due to the accident. Exhibit 9, the postmortem report of Deepak Kumar Sharma established the death of Deepak Kumar Sharma. Exhibit 2, certified copy of FIR shows that a case was registered against the driver of the vehicle bearing registration number so and so on the strength of an ejahar lodged by Srimati Bhanu Sharma, and Deepak Kumar Sharma was shown as the ill-fated person who succumbed to his injuries in the accident. It is contended in the ejahar lodged by Bhanu Sharma that on 5/12/13 at about 11:30 a.m. while her son Deepak Kumar Sharma came out of his home by driving motorcycle bearing registration number so and so on the left-hand side of the road in a slow speed. It is all repeat, Lordship. The speed to go to his place and work. Suddenly another vehicle bearing registration number so and so came from opposite direction and the driver of the vehicle was using his mobile phone at the time of accident. But Lordship, I'll read the FIR. This is not there, that mobile, though the court is connecting the FIR ejahar with the mobile phone. I have annexed it, Lordship. By seeing the motorcycle bearing number so and so coming from opposite direction in a rash and negligent manner, her son Deepak Kumar Sharma took his motorcycle on the extreme left-hand side of the road and almost stopped his vehicle. But Rajumoni Bora, who was driving the vehicle number so and so in a rash and negligent manner, came to the wrong side of the road, leaving his left side, resulting the accident. As a result of the accident, deceased sustained grievous injuries on his person, including head and chest. Immediately after the accident, deceased was brought to Kopili Hospital and then to BP Civil Hospital, Nagaon, and thereafter the deceased was taken to Dispur Hospital, Guwahati. Exhibit 3 charge sheet shows that charge sheet has been submitted against the driver of the vehicle number so and so IPC of IPC. The evidence of the claimant, eyewitness to FIR and charge sheet proves the fact that the accident was caused due to rash and negligent driving of the driver of the offending vehicle. Postmortem report established that the death of deceased Deepak Kumar Sharma was due to injuries sustained in the motor vehicular accident happened on 5/12/13. On the basis of above discussion, I have come to the conclusion that the claimant has proved the fact that the accident was caused due to rash and negligent driving of the driver of the vehicle bearing number so and so, and that the deceased Deepak Kumar Sharma died due to injuries sustained by him in the accident. Accordingly, the issue is decided in favor of the claimants. It is already proved that the husband of the claimant number 1 died due to the motor vehicle accident caused due to rash and negligent driving of driver vehicle bearing number so and so. The claimants are wife, mother, and children of the deceased Deepak Kumar Sharma, who died due to injuries sustained by him in the accident. He was the sole earning member of the family, and due to his premature death due to the accident, the claimant has found it difficult to maintain themselves. The claimants have preferred this claim petition under Section 166 MV Act, and as legal heirs of deceased being dependent on the income of the deceased, they are entitled to receive compensation. Now let us examine as to what should be the quantum of compensation and who is liable to pay the compensation. The claimants testified that deceased Deepak Kumar Sharma was a stenographer, Gethi confidential assistant in the office of Superintendent of Police, Nagaon, and earned monthly salary of rupees 33,728. It is disclosed that the age of her husband was 48 years at the time of occurrence, and the whole family was dependent upon the income of the deceased. Claimant exhibited Exhibit 10, a certificate issued by SP Nagaon relating to salary of deceased. Lordship, PW2 Sri Indra Mohan Kolita, who is the junior assistant of SP office Nagaon, disclosed that deceased Deepak Kumar Sharma, who died in a motor vehicle accident, was the stenographer in SP office Nagaon. He exhibited Exhibit 10 as salary certificate issued by the SP Nagaon, who succeeded the deceased as the stenographer of SP office Nagaon. He has also brought the salary register of SP office for the period of 2013. He disclosed that in the month of December 2013, the basic pay of deceased was rupees 16,400, DA 14,760, house rent HR rupees 1968, and MA 600, and his gross salary was rupees 33,728. He exhibited the relevant entry as Exhibit 151.3. In the instant case, the claimant exhibited Exhibit 10 as the salary certificate of deceased at the time of death. Exhibit 10, the salary certificate of deceased, shows that, again, that is repeat, Lordship, I'll skip that part. Honorable Supreme Court in Shambhati Sharma and others in current quoted held that where ascertaining income of deceased, any deduction towards GPF, life insurance premium, payment of loan, etc., should not be excluded from the. This same Shambhati Sharma, Lordship, I'll be relying on, because the court has. I'm not against that. I am not against that. It should not GPF or life insurance payment or repayment to loan. That is not to be deducted. No, but what the court has not deducted, Lordship, is the house rent allowance or the medical allowance, which was personal in nature. Medical allowance is always for the person, Lordship. So that is what is one of our ground, Lordship. Shambhati Sharma, I have also brought, wherein these are not to be, but those things are to be deducted. That is there. In Sarla Verma versus Delhi Transport Corporation, reported in so and so, the Honorable Supreme Court laid down the principles relating to addition to income towards future prospect. The Honorable Supreme Court held that whereas the deceased was below 50 years of age and had permanent job, the actual salary less tax. The court is mentioning this, what is mentioned in Sarla Verma. I'll show Sarla Verma, Lordship, that it should be actual income minus the tax. But here in this case, the court has not deducted. Though in this paragraph, the court is mentioning, the court has the knowledge that it is to be deducted. The tax has
to be deducted.
That is very clear. But less tax should be increased by 30% towards future prospect to arrive at a monthly income. In the case in hand, our hand, also the deceased was a stenographer grade 3 SR. As per the claim petition and postmortem report, his age was 48 years. So he had left a long period of service in the at the time of death. Definitely, there is scope of enhancement of income due to the revised pay and further increment. Relying upon Honorable Supreme Court decision, there must be addition of 30% to the actual income of the deceased while computing future prospect. This, Lordship, I'll show, Lordship, by Pranay Sethi also, and because Pranay Sethi is also relying on Sarla Verma, Lordship. whether this will be 30% or 25%, Lordship. I think it will get reduced to 25%, this amount, the 30% increase, Lordship, because he was 48 years of age. In the case in our hand, also the deceased was a stenographer of SP office Nagaon. As per the claim petition and accident information, the age of the deceased was 48. As per Sarla Verma reported, the exact multiplier 13 will be applicable to the purpose of computing the compensation in the Lordship. This we are not disputing. Multiplier, Lordship, is correct. In Sarla Verma versus Delhi so-and-so, it was viewed that where dependents are 4 to 6, a sum of 1/4 will have to be deducted, which the victim would have incurred had he been alive. Lordship, this 1/4 we are challenging because we have adduced evidence, DW, that the mother was not living with them and they have not contested that, Lordship. So children and the wife, they 3 of them were dependent, it should be 1/3, Lordship. That is what is our one of our grounds, Lordship. In Rajesh versus Rajbir, Lordship, I think this we can skip because Pranay Sethi has already said Rajesh versus Rajbir is not applicable, Lordship. So based on Rajesh versus Rajbir, any amount given, Lordship, that I will come to the calculation part, Lordship, I'll show. In the present case, the age of the wife is shown to be 40 years at the time of swearing the affidavit evidence. So she was quite young at the time of death of her husband. So applying the principle laid down by the Honorable Supreme Court in the above referred case and considering the age of wife of deceased, an amount of 60,000 is added towards loss of consortium. Whereas Lordship, Pranay Sethi has made it very clear that total amount is 70,000. And after 3 years, succeeding 3 years, 10% is to be added. In our case, Lordship, total was given 1,45,000. The conventional head, under conventional head.
No, this was decided before the Pranay Sethi's case.
That is,
So she has not included all those which was decided in.
that is true, Lordship.
So she will have to stick to Rajbir.
That time
and-
Pranay Sethi was then.
Yes.
Yeah.
At that time, Pranay Sethi came in 2017.
17 million. 2016.
My friend is
Now we
very,
can
no,
consider-
my friend.
No,
is
no, no, madam, no.
very-
Sorry.
He has filed a cross of objection appeal, Lordship, in that he is claiming as per Pranay Sethi.
No.
So I'm happy that he is.
No.
No. He's challenging these grounds only, Lordship. He has a cross objection.
No.
So I'm happy that at least he is now accepting Pranay Sethi said something. But Lordship, my humble submission will be that appeal is a continuation of the.
No, it will be considered, but at that time she was not aware of the Pranay Sethi's judgment. So these calculations were made according
As
to
per
the.
what was
yes.
prevalent then. I
Mm.
understand, Lordship.
Mm.
But then we challenged it, that this amount is also more. Because there were other cases in which that much was not given. Dear Lordship, I calculated loss of consort, Lordship will find at page 18, Lordship.
Mm.
Loss of consort.
Yes, I have seen page 18, yes.
Yes, 60,000, care and guidance 40,000. Even in Rajesh versus Rajbir, Lordship, and funeral expense 25,000, love and once loss of care and guidance, then again love and affection, Lordship. In those cases also twice that same compensation cannot be given twice, Lordship. Even if we say that Pranay Sethi was passed later on. But Lordship, 6, loss of care and guidance for minor children, and that is 40,000, and again love and affection. It should be one and the same, under one and the same head. And of course, after Pranay Sethi, that is not to be given. That is because Pranay Sethi, paragraph 54 of the judgment has mentioned it very clearly, that there is no provision in the MV Act for love and affection. There is no yet. So, Lordship, claimant number 4, Srimati Bhanu Sharma, mother of deceased, lost her son. So, an amount of 20,000 is added as loss of love and affection. In the case cited above, there are 3 minor children, and Honorable Supreme Court granted 1 lakh in total for loss of care and guidance for minor children. In the case in our hand, the deceased left 2 minor children. So, for loss of care and guidance for the 2 minor children, an amount of rupees 40,000 is added for loss of care and guidance. Claimant has submitted cash memo for an amount of rupees 5,80,000 for the treatment of this. So this is entire. Lordship, we are challenging this also because that's why I said all these documents are photocopies. Lordship. Because he was working in the SP office, Lordship, maybe he got reimbursement. So they could not give the original copies in the before the tribunal. All are photocopy. I have mentioned that, Lordship, in my argument also, which I'll be submitting. And I have from LCR, I have mentioned what are the, where are the, in which page of LCR the documents are there, Lordship. So we are challenging this 5,80,000, Lordship, medical expenditure. Photocopies, our own High Court judgment is there, Lordship. Photocopies cannot be accepted as proved exhibits, Lordship.
All right.
Then, Lordship, this last part, that now the question is who is liable to pay the compensation to the claimant. Learned Counsel for Insurance Company submitted that claimant number 4, Bhanu Sharma, mother of deceased, was not dependent on the income of the deceased as she was not entitled for any compensation. In this regard, insurance company examined one DW1 AA Barbhua investigator. He, during his testimony, revealed that the mother of the deceased used to live with his younger son, who is also a government employee. He exhibited his investigation report, which is Exhibit A, as per DW. So, Lordship, this Exhibit A also I will, because in that it is mentioned that a cross case was filed by the Raju, this driver of this vehicle, Lordship. And since the deceased was dead, that's why it was a final report, because this is Deepak Sharma, he died, Lordship. But FIR was filed to prove that the rash negligence of both the vehicles, Lordship, which is Exhibit A. As per DW1, the mother of the deceased was not dependent on the income of the deceased. On the other hand, learned advocate of claimant submitted that, considering the beneficial object of the act, mother being natural guardian who is more than 70 years of age is entitled for compensation as one of the dependent. After going through all the aspects in my considered view, the mother of the deceased being dependent is entitled for compensation. It is, Lordship, here the learned member is saying that the mother is entitled. Then I will come just to calculate the compensation, the 1/4, not to deduct for personal expenses, 1/4, Lordship, mother is there. But she is given lesser amount ultimately, Lordship. Why that was so? If she was really dependent, she should have got equal to any other person. But I think she was given 3 lakhs, 3 lakhs only. Though the judgment was of 58,23,000. If she was dependent, Lordship, it should have been equally. The court also understood that she was not dependent. So, Lordship, my humble submission will be in view of that. Maybe the mother, I do not have objection, she taking 3 lakhs, Lordship. I'm not going to argue on that point that the mother is getting 3 lakhs. What I want to argue is that since the dependents were only
1/3 is to be deducted.
Yeah, 1/3 is to be taken. That is what is my humble submission, Lordship. And the amount granted is also very high. So it doesn't make any difference to them if the mother gets 3 lakhs rupees. It is already discussed that the accident occurred due to so and so. So, Lordship, so the fact that the license, Lordship, the next paragraph is about license. We are not contending. We are not saying policy was not there. We are not contending about DL, Lordship. Then the court has come to the award and order, Lordship. Compensation was given as 58,23,392 with 7% interest. And the mother, Lordship, at page 20 of my memo of appeal and internal page 14 of judgment, mother was given 3 lakhs. So how can she be considered a dependent? Benevolent legislation, fine. She can get 3 lakhs, but she was, dependency is different from entitlement, Lordship. She was not dependent on the deceased, Lordship. Deceased, only the wife and 2 children were dependent on the deceased. So 1/3. Now, Lordship. I have made a small argument, written argument, Lordship. Lordship, number one, the photocopy, Lordship, that was Lordship at LCR page 207, Lordship. The pay for month December 2013, it is a photocopy, Lordship. Along with that, exhibit 2 to 6, 9, 10, 13, all photocopies, Lordship.
Yes.
Lordship, Evidence Act, Lordship, and section
Yes,
62 and 63, Lordship. Lordship found them, photocopies.
Yes.
Yes. So these are not to be considered, Lordship. So, our High Court one judgment, Lordship, Artha Pratim Roy, I am submitting. Herein, Lordship, it was. Yep. One by one, I'm submitting the judgments, Lordship. First one is regarding photocopy, Lordship. Our own High Court has given that.
Some are in original.
Yes, some are original. That's why I have mentioned the Lordship in my number one, argument number one, Lordship, I have mentioned. Exhibit 2 to 6, 9, 11, 13. Page 207, pay for month December, photocopy, Lordship.
Yes, yes.
So
207, 208.
Yes.
208 is not photocopy. This is called carbon copy, I think.
Maybe.
208.
That's why I have not mentioned that it is a carbon copy. I have mentioned because 207 is the salary based on
Yes,
which
yes.
the court has taken salary of 33,000 something, Lordship. So based on this photocopy, Lordship, how can the court come to? Either the case will have to go back for fresh trials, but already we have given 50%, Lordship.
But these are in original. Or
No,
the
not-
medical documents are in original.
No, Lordship, not all. I'll come to that, Lordship.
Some are-
At paragraph 8 of my argument, Lordship, I have mentioned about the medical document.
Some are this, what it is called, we get the slip from.
Doctor to
No,
buy.
no, these are not original, but these are from the downloaded copies. These are downloaded copies, I think.
But they have to be original, Lordship. And in my argument number 8, Lordship, I have mentioned, Lordship, why they do not get, because what they have done in the Lordship, exhibit 15, hospital bill of 2,19,470, that is the final bill. Then, Lordship, page 40,
No,
74,
but they have
70.
given bills and receipts also. Bills along with receipts. Some
No.
are downloaded copies.
No, Lordship, not all.
Digital bills. Some
Yeah,
are
no,
digital
Lordship.
bills from the computer.
Page 74, 76, 79, 80, 81, 82, Lordship, for rupees 2,40,050 are all advance bill. So they have given the final bill as well as the advance amount they had. So final.
And added together.
Yes. It
This is-
cannot be, Lordship.
Yeah, this is done usually, but actually it has to be, it cannot be included. Both.
Yes.
It's one and the same payment. Advance plus.
Yes,
Final
because
payment.
the final advance they paid fine
And
when
then
he was in the
deduct it.
hospital. Yes, and final bill is added there. And Lordship, page 83, if Lordship peruses, that is a refund voucher. That also the court has added. That is a refund voucher of 20,600.
Page?
Page 83 of LCR, Lordship.
Yes, yes. Yes, page
So the
83.
court has not looked into all the, whatever the claimant has said, we have spent 5,80,000, the court has straightway given the amount.
Are you sure this has been added by the court refund voucher?
Yes, that is the total amount. Maybe they calculated and they gave the court and according to the.
Lordship, I'm not interfering with, but perhaps this submission only on argument part lordship will whether entered by your lordship is this is a matter of question, because lordship will, if lordship is found read the grounds regarding this photocopies and others not taken,
No, Lordship has.
whether only on oral submission and not even in the evidence stage of when
WS.
yes, when executing this case, even this ground, my lord, there is no ground regarding this they disputed the medical bills, my lord.
No, I think she must have stated in the WS.
Only
Yes,
only on argument sake of argument, that cannot be, my lord.
No, Lordship, this is an appeal and Lordship will
No, there has to be a ground, no?
Lordship, no, in any other ground, there is always, we mention any other ground. In any view of the matter, Lordship, we can include, and Lordship being the first appellate court, Lordship.
Lordship,
will
there is
to
no
evidence
word, there no word, any other ground.
in any view of the matter.
There is no, where is any view of the matter?
Page 5.
That is any view of the matter, that cannot be. There is any plea of
Anyway, Lordship,
erroscopy is
arguing he can submit
No,
when
no, Lordship.
he does the Lordship. Thing is, Lordship, this is the appellate court and I have every right to point out, Lordship, what are the wrong in the judgment, Lordship. By giving, and Lordship asks that if the court calculate, yes, Lordship, the court came to that 5,80,000 by calculating, double calculating, as well as refund voucher are calculated. So, Lordship can very well look into that. There is nothing wrong in that.
Yes, yes, can look into.
Yes, because this is monetary matter, Lordship.
All right.
Then, Lordship, my argument number 3 is, Lordship, head-on collision. While reading the judgment also, I was mentioning that it was a head-on collision. For that, Lordship, I have given the judgment of Vijay Kumar Dukkar, Lordship. It was the case has gone from our High Court, Lordship, and the Apex Court held that when there is a head-on collision, then both the vehicles are liable. So my humble submission is that the contribution made by the deceased was 50%. We have already deposited 50%. They have taken it. Our liability is no more there, Lordship. Because, so this is that on contributory negligence, Lordship. Then my next ground, Lordship. For this contributory negligence, our High Court judgments also I have given, Lordship, Damayanti Boro and also Abdul Jiyat, Lordship. This on contributory negligence itself, Lordship. Then, Lordship.
I did not get the Abdul Jia judgment. Damayanti Boros I have.
Damayanti Boro.
Oh, yes, I have.
Damayanti Boro and Abdul Jiyat. In Abdul Jiyat, Lordship, in these cases, I had argued, Lordship, so I know these judgments. Abdul Jiyat, no compensation was granted because it was his own fault. And Damayanti Boro, Lordship, the contribution made by the deceased was then, Lordship. Then, Lordship, my fourth argument is regarding income tax deduction, Lordship. I have submitted Sarla Verma's judgment, Lordship. In that it is clearly mentioned the income, actual income minus the tax should be accepted. Already Lordship knows that, Lordship, the paragraph. It's not my mark.
Okay, I'll check it.
No, okay. Otherwise, this is not my marked copy, Lordship. That's why. Anyway. Then, Lordship, Shyambati Sharma, Lordship, I have given Shyambati Sharma what is to be deducted. The court has mentioned about GIC and we do not have any problem with that, Lordship. what we want is that the house rent allowance and Lordship, the court has mentioned in paragraph 8, Lordship, of Shambhati, GF life insurance premium payment of loan should not be excluded from the income. We do not have that. The court has not excluded, Lordship. But what we want is that the house rent allowance and medical allowance is to be deducted because they are personal in nature. In Shambhati Sharma, that is what is mentioned, Lordship, that something which is personal in nature is to be deducted. But GPF and income tax here, those are, Lordship, of the benefit goes to the family also. So we do not have any problem with that, Lordship. Then, Lordship, 7th ground is conventional head, Lordship. I have given pronunciatory judgment, Lordship. Conventional head should be 70,000 and added 3 years. Paragraph 54.
Paragraph 54, no?
No, 54 to no, 50. Yes, 54. In pronunciatory, Lordship. Then, Lordship, in 6th, Lordship will peruse exhibit 12, which was exhibited by claimant themselves, Lordship. That is the legal heir certificate. And only 3 legal heirs are mentioned in that. Mother is not mentioned, Lordship. This is for my 1/4 and 1/3 deduction. Their own document, Lordship, legal heir certificate. Conventional head is higher. Then, Lordship, I have already showed bills and voucher. 8 is about bills and vouchers, Lordship. That the exhibit 15 is hospital bill, that is the final bill. And 74, 76, 79, 80, 81, 82 are advance bills, Lordship. And that is also included in that 5 lakhs. Otherwise, it doesn't. It will come to 2,19,450, Lordship, the medical expenditure. The court has given 5,80,000. That is not so, Lordship.
How much according to you?
2,19,450, Lordship. That is the final medical bill, Lordship, from hospital, because he died in the hospital itself. So, no, I don't know.
2,90,450.
Huh. Then, Lordship, and 9 is that we have already deposited 25 lakhs and they have taken that amount, Lordship. So our liability is over because we are saying that was contributed in negligence. So if 50% is given to the contribution of the deceased is considered, then we do not have any more liability, Lordship. We have already paid the amount, Lordship. And Lordship, 10 number is regarding their cross objection that they have asked for interest, for higher interest, I suppose. So I have mentioned here itself that the claimant delayed. So claimant delayed the disposal. So there is nothing wrong in the interest granted. And 11th is, Lordship, our statutory deposit may be allowed by us to be withdrawn, Lordship. And in his cross objection, if he says something, Lordship, I reply.
May I please, Lordship? Lordship, regarding facts, my learned friend already stated before this honorable court. Lordship, accidents took place on 5/12/2013 at 11 AM while husband of the S1 number 1 claimant came out from home, and that was. And regarding in this case, is Lordship go by the ground taken by the appellant side, my lord. Here, Lordship may be allowed to read the grounds, my lord. First ground is that FIR was lost after 12 days, my lord. That is one of the ground, and for that, this appeal should be allowed. And second ground is that res ispa liquidator. On that ground, I will argue, my lord. That is contributory negligence. Third ground is that third ground that fact considering the accident was due to head and collision contribution toward made by deceit was which is more due to the fact that this is driving or an authorized vehicle without driving license. That was held to prove that he was under that plea was never failed to prove that he was unauthorizedly drive any vehicle. Fourth ground was that medical allowance 600 should be deducted. And E failed to consider that tax pay salary being 30,728 per month, but learned court below has not deducted any amount of tax before actual income of that was lordship. I can show that tax was deducted after deducting gross amount was fixed.
Okay.
And next is Milord, court failed to consider that murder of the deceased was not part of the Milord. Murder is natural dependence. She is aged with about 70 years, and even Sorla Burma case, Milord, it is held that murder is a natural reason. But then there is no question of denying any compensation to him, Milord. And so far as the ground G regarding PW2, who was an eyewitness, there before the trial court, Milord, there is no evidence adduced by the appellant side that to rebuttal to his testimony. Insurance company never produced, did not produce any evidence to rebuttal that. As such, his testimony is unsecond, Milord. And regarding, Milord, contributory negligence, Milord.
Yes.
It is the law that the claimants required to prove the case on the assumption of preponderance of probability, Milord.
Yes.
Notice not the beyond reasonable doubt.
Yes.
In this case, Milord, the case was registered against the driver of offending vehicle and charges was filed. But necessarily, Milord,
Yes.
negligence on lies on his part, Milord. In this regard, Lordship, I'll rely on the judgment that is these are the judgment, Milord. Lordship, first point is that regarding contributory negligence, Milord. Lordship may, this is the Bimla Devi judgment, paragraph 15, Milord.
You are for claimant.
Yes.
Para 15?
15, 1-5. May I read, Milord?
Yes, yes.
In a situation of this nature, the tribunal has rightly taken a holistic view of the matter. It was necessary to bear in mind that stick over an accident caused by a particular bus in particular manner may not be possible to done by the claimant. Claimant were merely to establish their case on the procession of preponderance of probability. The standard proof beyond reasonable doubt could not have been applied. For the said purpose, High Court should have taken the consideration of respective story set forth by the parties. Milord, in this case, regarding before the trial court, there is no evidence regarding rebuttal of eyewitness, Milord. Only this plea is taken before this honorable court, Milord. And second is, Milord, Deccan, Fernandez and others, that is para 7 and 12, Milord. At para 7, Milord, it would hardly need a mention that plea of negligence on the part of first respondent who was driving the pickup van as set up by the claimants are required to be decided by Tribunal on the constitution of preponderance probability, and certainly not on the basis of beyond reasonable doubt by relying the previous judgment, Bimala Devi Milot. And next, paragraph 12 Milot. CW2, who was at the time, 11 time working the head constable of the main Aerotorium police station, had deposed that a criminal case was registered against the first respondent in this connection with the accident, and after investigation, he was suscited and sent up for trial. Though it is submitted at the bar that the first respondent was acquitted in the case, what cannot be overlooked is the fact that upon investigation of the case registered against the first respondent, prima facie material showing negligence were found to put him on trial. In this case also, charge sheet was filed against the driver of offending vehicle. And so far as plea taken that driver of the offending vehicle lodged an affair, and that was abated because of this person died. But that was never pleaded either before tribunal nor even ground taken in this case.
Lordship, can I just, Lordship, I mentioned at page 207, Lordship, in the LCR, Lordship will found Exhibit A. Exhibit A exhibited by the DW. DW was adduced. It is not a fact, Lordship, and DW without objection that exhibit investigation.
There has to be some evidence on the part of insurance company, my lord. Without
evidence only.
without any,
DW was our.
no, my lord. I read to the DW what DW stated before tribunal, my lord. And that was the case. And another case is, my lord, that is Manglaram versus Oriental Insurance Company. There is paragraph 27 and 33, my lord. That is regarding contributory negligence, my lord. My lord. Another reason which wait with the High Court to interfere the first appeal filed by the respondent 2 and 3 was absence of finding any tribunal about factum of negligence on the part of subjective. Factually, this view is untenable, my lord. Our understanding of the analysis done by the tribunal is to be hold that jeep number so-and-so was driven negligently by respondent 2 when it collided with the motorcycle of appellant leading to the accident. This can be discerned from the evidence of witnesses and the contents of charge sheet filed by the police, namely respondent 2. This court in recent case, Dulisina Fernandez noted that K negligence on the part of driver of the following offending vehicle as set up by the claimant are required to be decided by the tribunal on the system of preponderance of probability and certainly not by the standard of beyond reasonable doubt. Suffice to observe that exposition of this judgment already averted by us, filing charge sheet against the respondent 2 prima facie points toward his complicity in driving the vehicle negligently and rashly. Further, even when accused were to be acquitted in the criminal case, this court opined that the same may not be or may be of no effect on the assessment of liability required in respect of motor accident. Here also, my lord, no doubt, DC was driving. Okay. And next paragraph, my lord, paragraph 33, my lord. In other words, we are inclined to hold that there is a little of evidence about the motorcycle being driven negligently by the appellant at the time of accident. Respondent did not produce any evidence. In this case, also, there is no evidence regarding his negligence by the deceased person. In fact, therefore, cannot be assumed that resultantly argument of the respondent that the appellant did not possess valid motorcycle driving at the time of accident will be no significant. Thus, we hold that there is no legal evidence to answer the issue of contributory negligence against the appellant. My lord, if Roxby allow me to one paragraph in the judgment, my lord, judgment award passed by the trial court, my lord. At page 12, my lord. Page 12, my lord.
Yes. Page 12.
Defense, though cross-examine his witness, this witness, that is eyewitness, my lord, PW2, thoroughly yet could not assail her evidence regarding rash and negligent driving of the driver of the offending vehicle for whose fault the accident. On careful appraisal of the testimony of eyewitness PW2 Chandrakanta Roy, who claimed himself as an eyewitness to the occurrence, it appears that he clearly revealed the accident happened to the rash and negligent driving of the driver of vehicle bearing number, registration number so and so. His appearance at the place is found to be quite natural. The OP could not dislodge the testimony of PW2 regarding the above fact. He reiterated that the accident took place due to rash and negligent driving of the vehicle bearing registration of so and so. Insurance also did not adduce any evidence in rebuttal to the testimony of this witness. There is no evidence regarding that there was a rash and negligence on the part of this person. And so far as search sheet is concerned, search sheets were exhibited, my lord. That was exhibit number perhaps 3, exhibit 3, the search sheet, and that was search sheet against the. So there is no the question of contributory negligence cannot be lordship.
No
And,
contributory negligence.
And so far as my lord, murder is a
Mother.
dependent or not. In Sarla Boma case, my lord, paragraph 32, my lord. Thus, even the deceased is survived by parents and siblings, only mother would be considered to be dependent. And another line, mother alone be considered as a dependent. Necessarily, mother is dependent. And so far as, so if mother is considered to be a dependent, then 1/4 deduction is right. That is paragraph 30 of Sarla Boma case. May I read, Miller? Though the some cases the deduction to be made toward personal and living expenses is calculated on the basis of unit indicated in Tilak Chandra, the general practice is to apply standardized deduction. Having considered several subsequent decisions of this court, we are of the view that where the deceased was married, deduction toward personal living expenses of the deceased should be 1/3, where the member of dependent family is 2 to 3, and 1/4, where the member of dependent family member is 4 to 6. Here, respondent number 1 is the claimant, 2 and 3 is the son, minor son and daughter of the deceased, and 4 is the mother, that is the 4 dependent. So, Lynette Tribunal rightly deducted the 1/4 since it was 4 dependent. And so far as deduction of taxes is concerned, my lord, Lordship kindly peruse page 15. my lord.
Page 15.
Page 15 of Apple Memo 1/5, the judgment part, my lord. Second paragraph. In the instant case, the claimant exhibited Exhibit 10 as salary certificate of the deceased at the time of his death. Exhibit 10 salary certificate of the deceased shows that basic pay of so and so, so and so, so, and gross salary is 33,728 million. After deduction of GPS, GIS, personal tax, the net salary deduction is shown 31,320. And I'm skipping this part, my lord. The last sentence, my lord. After deduction of P-tax 228, the net salary of the deceased will be 33,520. That one means, my lord, tax is deducted.
This is professional tax, Lordship.
Wha-
Sarla Verma is
how-
talking about income tax. No, Sarla Verma is talking about income tax.
Tax is deducted. my lord.
This is professional tax.
After, because he is not professional person, he is a salaried person, my lord. He was salaried.
Directly.
Normally, professional taxes is different and salaried person cannot be professional, my lord. Anyway, my lord,
No,
tax is deducted,
P-tax is professional tax.
Yes, professional.
tax is deducted, my lord. And so ground taken here, and so far as Xerox copy of submitted before the
His income tax would be around something, I think.
in that case, my lord,
20% if they do
No,
not
no.
give.
in that
bank
case,
account,
I have the slab,
No, here it will be less
No.
because that there'll be deductions also.
Huh.
And
I don't know,
think
Lordship. The court has
yeah,
to calculate that.
there'll be
because what-
deductions.
Lordship, in that case, Lord,
Yeah, investment and everything after calculation, it will come to, I think, around 10% only.
Maybe whatever, Lordship, but the court should deduct that before calculating. And because, Lordship, he has read it, again that part comes that the court itself came to the year that 31,000 something is there, but the income was taken as 33,000. Lordship at page 70.
Lordship, it is a
But-
case of 2016 and 17. At that time, the incomes of tax levies up to here, my lord, their pair is
Income
the,
tax.
yes, their pair is the 30%. That is not that who got the salary income annual income 10 lakhs, then only 30% of deduction is coming to me. But here in 2016-17, the taxable income to 2,50,000 is nil, my lord. And 2,50,000 to 5 lakhs, 10%. This is the slab of
Yes.
so my lord, that cannot be 30%, my lord. And
No, no, no.
oh, lordship.
Even if it is 30%,
Lord.
after deduction, it will come down.
Yes, yes. Even his even as per my calculation, my lord, he is not his gross amount is annual was not
Not taxable,
yes.
maybe.
It cannot be, Lordship. Well, the income taken 33,520 for calculation at page 17, Lordship. That itself, if we multiply, we get
12.
And so
Yes.
far as ground of Xerox copy, that was not before plea as well as before only on
See, the main pivot of the case,
yes.
that your income tax certificate is Xerox copy.
No,
That's
my
what
lord.
she is saying.
No, no, that was lordship kindly
Not
have,
income tax certificate, your salary
sir,
certificate.
kindly have a look, my lord. There is a witness, official witness. He was adduced. That is the PW3.
Okay, then it's okay. It's okay. It's
Lo-
okay, it's okay. I have overlooked that. I've gone through it, it's okay.
Yes.
Yes.
Lordship will find that.
No, I have read it.
Yes.
Not me, she has read it.
Yes. PW3 is the official witness who produced before.
Yes, yes, yes,
record.
yes.
That there is no dispute regarding its salary amount.
That salary slip,
Yes.
okay. But she has stressed that it's a Xerox copy.
Yeah, maybe in that point of time, my lord, it was typewriting copy printed through typewriter, my lord.
Photocopy.
Maybe,
It's a photocopy.
maybe. But that was exhibited by the official witness.
No, it's okay.
So, more humble submission is that, my lord, ground taken here is that and contributing knowledge cannot be applied. And so far as murder is a natural dependent, even though amount awarded to a lesser, but there is no complaint since all are living together, my lord. There is no question of any irregularity in that. And so far as deduction of tax and 30% as claimed by the appellant side is not applicable in yes, my lord. And so far as medical document means, so that was placed by the place obtained from the hospital where he admitted and died. And petitioner is not making any claimant is not making any document or voucher of her own, and that was placed as provided by the hospital where he is admitted and died. And as such, my humble submission is appeal is not maintainable and amount to be
Okay.
and
According to you, there is no contributory negligence. The judgment is correct.
Yes. And so far as and apart from that, my lord, I have also filed an cross.
Yes, yes.
That is, my lord. Basically, 3 ground, my lord.
I have seen the case.
Losses. There is no amount just toward love and affection toward only 20,000 is given. But as per law, my lord, this amount should be given separately to both of the child, my lord. And line and apart from there is no compensation toward loss of estate. That was not given here. And so far as interest part is that is 7% from the date of judgment. And it should have been from the date of application,
filing.
because this lawsuit closed the record. Case was filed perhaps in the March 2014, and claimant filed their evidence 28/2014. There is what after 4 or 6 days. And on the date on which date it was fixed for filing evidence, on that date they file evidence. There is no question of any negligent delay on the part of claimant. So
Okay.
it should be the interest should
Date
be
of filing
paid.
of petition.
And my prayer is that rate of interest should be enhanced up to 12%, because I am relying some judgment here, my lord.
Jason, itu Jason.
This is Kajal versus Jagdish Sangh. Paragraph 31 interest. I'm reading in the paragraph 12, my lord. Normally, the interest should be granted from the date of filing of petition. If in appeal enhancement is made, the interest should be again be from the date of filing of the petition. It is only if the appeal is filed after an inordinate delay by the claimant. Or paragraph 31, my lord.
Okay, okay.
Second paragraph, my lord. After quotation of the section 171, my lord. Does you got it?
Yes, yes.
Normally, interest should be granted from the date of filing of the petition. In the appeal, enhance is made. In appeal, enhancement is made. The interest should be again be from the date of filing of the petition. It is only if the appeal is filed after an inordinate delay by the claimant or the decision of the case has been delayed on account of negligence of the claimant. In such exceptional cases, the interest may be awarded later date. However, while doing so, tribunal or high court give reason why interest is not being paid from the date of filing of petition. Therefore, we direct that the entire amount compensation, including the amount enhanced by us, shall be carried an interest of 7.5 per annum from the date of filing of the claim petition till payment of deposit. This is the case of 2020. And another case, my lord, that is Puttuma versus KL Narayan, my lord. That is paragraph 57, my lord. How to, here, my lord, the Supreme Court discuss how to calculate the interest, my lord. I'm reading 58, paragraph 58. The rate of interest provided and granted under different act is under Section 4A3 of Workmen Compensation Act 1923 provide payment of interest at the rate of 12% per annum or at such higher rate not exceeding the maximum rate leading to the rate of scheduled bank or for delay payment of compensation. B. Consumer Protection Act, even though provides no provisions for grant of interest, this court has granted the interest of invoking Section 3 of Interest Act and Section 34 of Code of Civil Procedure has awarded the interest 12% to 18%. The land acquisition case provide for the interest for delay payment 9%. The Arbitration and Conciliation Act provide for so and so, so and so. So, in view of and these are the judgment relied by the Supreme Court and 62, my lord. In view of above provision of Act and observation, the notice that we keep the question open for trial court to decide the rate of interest after taking into a consideration of rate of interest allowed by this court in similar cases and other factors such as inflation, change in economy policy adopted by Reserve Bank of India from time to time, the period of since when the case is pending. In this case, 7% is less, so my humble prayer is that should be enhanced to some extent, my lord.
Okay.
And in this case also that some enhancement was made, my lord, and after enhancement, my lord, 12%, my lord, here 12% is fixed at 64, my lord. And there shall be get interest on the enhanced compensation at the rate of 12% per annum from the date of filing of complaint petition.
Yes.
So, my cross appeal, my fear is that there is no amount granted toward loss of state, and law of affection is granted for 20,000. That should be separately, even 20,000, 20 to 40,000. And since there is a 2 sons, and interest rate should be enhancement.
First, let me reply to his cross objection, Lordship. He has just himself read judgments, Lordship, in 7.5% in MSc case. 12% is workman compensation, Lordship. That is in the act itself is 12%, or it can be higher than 12%. MSc it is as per bank rate. His own judgments, Lordship, Kajal versus Rajesh, which he has showed, that is 7.5%. Court has given 7%. And Lordship, when I argued about the conventional heads, Lordship, being given 1,45,000 on higher, he said Pranay Sethi came later on. So his ground for loss of estate and love and affection and whatever, these judgments have come later. So how does he get a benefit of that? If he gets, I also get, it gets reduced. That's simple mathematics, Lordship. And Lordship, about rash and negligence, Lordship, I'll read only one line of the judgment I have given, Lordship, Dukkar case, Lordship, paragraph 12. Bijoy Kumar Duggar versus Vidyadhar Datta. This had gone from our High Court, Lordship.
Yes,
Paragraph 12, Lordship, last line.
yes.
There is discussion in, I'll come to the conclusion. But when the vehicles had a head-on collision, the drivers of both the vehicles should be held responsible to have contributed equally to the accident. In this case also, Lordship, one of the driver, he died and the claimant had gone to the apex court for increasing the court said, no, the contribution made by him, that is to be deducted. So that 50% was deducted here. So I'm just showing that one sentence. Because the judgments he showed, Bimla Devi and preponderance of probability, we are not denying. Here, it is not a question of, we are not denying.
Well,
that-
whether the other vehicle was made a party?
No, they did not make. They deliberately did
That
not
was
make.
not the issue for the tribunal.
No, now Lordship, he said that we have not exhibited
Then
anything.
if I come to a finding that the other party is liable, then it will have to be remanded.
And even lordship will find
Lordship, may I submit?
there is no even evidence adduced
That is
by
what I'm
any.
coming to. Lordship will peruse, we have exhibited that Lordship will find in page 207 of the LCR. Cross case is mentioned in that, that is exhibit A we exhibited. And DW was adduced, that exhibit A is the investigation report, Lordship. If the person Deepak Kumar Sharma, if Jodip, he has died, Lordship, how can there be a charge sheet against him? That is why there is no charge sheet against him. But exhibit A, it is clearly mentioned that
We have lost a charge sheet.
yes, the driver, Lordship,
We have
Raju,
lost an FIR.
Raju had lost, not the insurance company, Lordship. The Raju Muni Bora, he had lost the FIR. But since the Deepak Kumar Sharma had died, Lordship, so it was closed. Deceased person cannot have a charge sheet, Lordship. So that is my submission there. And then some other submission was made about Sarla Verma, Lordship, bachelor. That is the paragraph about bachelor. If there is a bachelor who has died, then only the mother will be taken as. And if they go by that paragraph 31 of Sarla Verma, Lordship, then 50% deduction. If he is relying on Sarla Verma paragraph 30 and 31, that mother is the legal IRNA, then Lordship, it will be 50%. No need for 1/3 or 1/4, Lordship. We can go by, I do not have any problem with that. And legal IR certificate they have exhibited. I mentioned in my argument, legal IR certificate they exhibited, and in that only 3 persons are there, legal IR. The wife, children. That is, Lordship, exhibit 12. That was exhibited by them. On that ground also, and DW we adduced, DW also said.
I have noted it.
Lordship?
Legal aid certificate.
Yes.
And then exhibit A also, I have noted down in
Yes,
our argument.
Yes.
Let's see what
Lordship, exhibit A, investigation report. There is no mentioning about regarding
FIR lost by Raju Mani.
yes.
No,
Yes, this is the part of judgment 21 million.
Judgment, we are not, we are against that judgment. That's why we have filed the appeal, Lordship. They did not come for
Lordship,
appeal, Lordship.
exhibit
They
A is the information report.
investigation report, not information.
By
report.
investigation report, Miller.
It is full. And in that everything is.
That is exhibited by OP.
And the PS case, Lordship, is also mentioned in that PS case number 2037 of 13. That was lodged by Raju Manipur.
Third learned counsel Miss R.D. Mudumdar for the insurance company, and learned counsel Mr. P.K. Medis.
No, Miller.
M. Mohanty
M. Mohan.
for the claimants. Because we have a cross objection, that is why
Yes.
I'm mentioning you as claimants. Reserve for judgment and order.
Highly obliged, Lordship. Next to Korean channel. Hotel to Korean as well. Lordship, this will take some time. So should we do it started today or we can
I won't be able to
deliver?
absorb anymore today.
I know, Lordship, because since morning
I'm
Lordship
not
is
being-
hearing.
I'm not being receptive now very much. No,
That is what I was telling.
Till your argument, I was
Oh,
receptive, not now, not anymore.
That's what I was just telling him. From morning, Lordship
This
is
is the
hearing,
third
hearing,
argument.
hearing.
Yes, this is the third argument. One I have delivered judgment also, and two I have kept reserved.
That's
So maybe it won't be very receptive.
humanly not possible there.
Yeah.
Hmm?
Uh,
Nine.
list this matter,
Madam,
14 and 15.
on
List this matter on according to your convenience.
9 minute, 9th of September.
Open a 9th. Yes, on 9th.
Obliged.
Obliged.
May I please your lordship, item number 22, supplementary hearing.
Oh,
Your lordship may be pleased to fix, my learned friend is also present.
I am for the respondent lordship, respondent insurance company.
22.
Item 22 supplementary discount.
Lordship,
there was a request for listing this.
Yes, yes.
Item.
Mentioned.
Huh?
No, no.
no,
that
no,
is
your
not.
lordship. It is
No,
hearing.
It's for hearing. Lord.
Hearing.
Okay, then I'll fix it for hearing. When do you want?
Your lordship, that my,
It is. That is a plan.
so,
Tension with the. I will reach now for.
there is. Plug it in. With the 10, 16. Your lordship, 16 October, after
Is this
vacation.
matter for hearing on 16 October? No?
17.
Huh? जान ले लो ये।
17. Can it be 17?
कार birthday?
17 to get 17.
17 also hearing day no है ना?
Hearing 17th. Hearing day, no? 17th. Okay, yes.
Oblige your lordship. Hello, 16. Date may fix na
Yes, yes.
After vacations.
After vacation?
I thought it detailed, but it is short matter.
28 October.
October 28th.
हाँ होगा 28
You want a date or should I fix it after vacation?
No, no, my lord. Date may fix.
Okay, list this matter for hearing on 20 October.
28.
28 नहीं 28 okay?
हाँ
28?
हाँ 28 तारीख ना? Grateful.
17, my lord, it may only come up after vacation, my lord.
Come up later, no?
My lord. Immediately after vacation.
Okay, list this matter for hearing on after vacation, puja vacation.
My lord. Obliged.
Lordship, there is an inferior order here. And
Which one?
18, 19. 18 and 19.
18 and 19. List this
Inferior
matter.
order is operating in item number 18, FAO.
Ah,
But in the contempt application petition, they have been seeking time since last 2 occasions
okay.
to file affidavit in opposition.
We'll give you
And-
a short date.
Yes, your
Maybe
lordship.
after 2 weeks, my lord. The date may be fixed
A
after.
date may be fixed because they have been continuously
Okay.
carrying on the construction work.
2 weeks of 18 September.
18.
List this matter for hearing on 18 September. Item number 18 of Likhit interim order shall remain in force till then.
Lordship, a last chance may be given to file. the
Last chance is accorded for hearing.
For filing of the affidavit in opposition in the contempt.
Okay. Last chance is accorded for filing of affidavit in opposition.
Deeply obliged.
Release this matter after 2 weeks. Oh, huh? আহি যাম 4 PM আধা ঘন্টা আছে মই এনেই কৰি দিম পৰা আছে চশমা নাই আনিছো Petitioner is granted interim bail for 2 months from the date of this order to undergo treatment for his ailment. After 2 months, the petitioner is directed to surrender before the Learned Trial Court and cooperate with the trial. List this matter on 3/9/2025. Huh? Oh.